For motion, item 1.
May please, Your Lordship. My Lord, this is an application under Article 226 of the Constitution, my Lord. My Lord, the lands and the crops of the petitioner
No,
hearing.
just a minute.
My
Where's the file? Give me the file. You're mentioning. Are you mentioning or moving?
Moving, my Lord.
Okay. I didn't have the file,
Appellation,
that's why.
my
Okay. What is your case?
Lord, the lands and the crops of the petitioners herein, my Lord, covered under P. Pata Pirik Pata number 101 of 2007, my Lord, which is located at Sairang, Mizoram. It was acquired by the respondent number 1 for the construction of National Highway number 6. And my Lord, the respondent number 6 had already passed the 3G award dated 30/4/2025, my Lord. And as per the said 3G award, the petitioner herein is to receive an amount of 1,9,09,585, my Lord. So the other landowners whose lands are also acquired by the respondent number 1, they have already received the amount of compensation payable to them commencing from 26/5/25, my Lord.
Okay. 3G award is determined.
Determined already, my Lord.
But the amount is not paid to you.
Not paid.
Why?
My Lord, representation was
No, why
submitted to
is it
the
not paid to
respondent.
you? According to you, why not paid to you?
that is the
Is there any other issue, any
there is
dispute?
no specific reason to our knowledge, my Lord.
How many petitioners are there? 2.
One,
One. Okay. Who's supposed to pay you this amount?
this is the Kala, my Lord. This is respondent number 6. This is the competent authority, additional DC, Aizawl district,
This is for what? Construction of highway?
highway, national highway number
National highway? Where's the
number
detail?
6, my Lord. This is located at Sairang, Mizoram.
It was determined in the month of April this year. 30 April, isn't it?
My Lord.
Then where's the award? Page number?
Page number 44, my Lord.
44.
And the land of the petitioner is at page number 47, serial number 75. Serial number 75, page number 47, my Lord. My Lord, the registered owner, this is Zhou Mingtang, he already gave the landed property to the instant petitioner by executing a gift deed, my Lord, before the acquisition process.
Serial number?
75, which is in page number 47.
47.
47.
Serial number 75.
75, my Lord.
What is the name?
The name is Zhou Mingtang.
Okay. How much is the amount?
The amount is
1 crore.
1,09,09,585, my Lord.
This is not given to you.
No, my Lord. And my Lord, a representation was submitted to the respondents, which is in page number 49. Page number 49, my Lord. So this is, my Lord, dated 11/8/2025.
It's a notice under Section 80 CPC.
My Lord. So this has not been disposed of, my Lord. So at this stage, my Lord, I kindly pray for a direction to dispose this representation, my
This
Lord.
is not a representation. This is a notice under Section 80 CPC. What is the date of the notice?
Date of the notices, my lord, 11/8/2025. 11/8, August.
So what is the requirement under section 80 CPC?
60 days, my lord.
60 days. 60 days period has to lapse. Yes, Miss Mary.
Your Lordship, in this petition, they have annexed, Your Lordship, previous order, which is in page number 84. The relevant portion is in page number 94. Your Lordship, in this, Your Lordship was of the opinion that since there is no period of limitation prescribed for filing an application by an aggrieved party under Section 3G of the National Highway Act, liberty should be given to respondents to avail the remedy available. Now, why I'm pointing out is that there is no such application that is annexed in the petition here.
No, limitation for what?
For submitting an application under Section 3G of the National Highway Act.
What is that? 3G provides for?
Your Lordship, complaint. It's a complaint. Complaint to the Kala by way of an application.
No, here the case is that some award has been made.
Yes.
That amount has not been paid. Complaint is regarding non-payment only. It is not on the quantity, isn't it?
Yes.
So whether there any provision which says that you can file complaint would cover this case.
My lord, if I may, the determination of the dispute regarding the, besides the amount of compensation, were already, my lord, settled in 3C of the Highway Act, which is notified under the section 3D.
Now, what is 3C?
3C is the complaint, my lord.
See, are you aware?
Objection.
Are you aggrieved with the amount of?
No, my lord, no.
You not the amount, only non-payment.
Non-payment.
So the grievance is regarding non-payment,
Non-payment.
not the quantity.
Not the quantity.
This it's too less or something like nothing like that. They say that we have to be paid. That's all. So for that, what is to be done? Will issue notice at this stage?
Yes, Your
My
Lordship.
lord.
Art Mr. Benjamin Lalsamwana, learned counsel for the petitioner, who submits that although a 3G award under the
National Highways Act, my lord.
National Highways Act,
1956.
1956 has been prepared by the respondent number 6 on account of acquisition of the land of the petitioner. White notification dated 3/1/2. What is the notification?
Notification,
Is it page 40?
my lord, we are talking about the 3A or 3G, my lord.
3G?
3G. 3G is in page number 44, my lord. The
What is the date?
30/4/2025, my lord.
Okay.
34,
Notification you cancel. Instead you write on 30/4/2025,
my lord.
comma, the amount so assessed has not been paid to the petitioner. Stop. Okay, what about the others? Have they been paid?
My lord, as per my information, they have already been paid, my lord. Commencing from 26/5/2025, my lord.
Stop. The learned counsel submits that in respect of the others enlisted in the award, they have already been paid the compensation. Stop. The petitioner being aggrieved had served notice under section 80 CPC to whom?
To the respondents number 1, 2, 6, 7, 8, 9, and 10.
Okay, to the respondents, but till date there is no response.
My lord.
Stop. Aggrieve the petitioners before this court. Next para, in view of above, issue notice of motion returnable by 4 weeks. Ms. Mary L. Kiangte, learned government advocate, accepts notice on behalf of respondent numbers 2, 3, 4, 5.
5. 2 to 5, Your Lordship.
Okay, and 5 only, huh? While Mr. T. Zekima,
I can accept notice on behalf of NHIDC.
respondent number.
7.
While Mr. T. Zekima, learned counsel, accepts notice on behalf of respondent number 7, 8,
9 and 10.
9, and 10. Then CGC is not there? Ministry of Road Transport? Who will accept notice?
We did not receive petition copy as well as.
You still have a copy?
My lord.
Miss Baby Laldin Zwali, Lanet. Are you CGC or not? Not yet. Laldin Zwali, Lanet Council accepts notice on behalf of Miss Zairam Sangpui, Lanet CGC, representing respondent number 1. Stop. The petitioner to serve requisite copies of the writ petition to the Learned Council appearing for the respondents today, within 2 days. Petitioner to take steps for service of notice upon respondent number 11 by registered post with a review within 3 days.
Your Lordship, in respondent number 6, that is Kala.
Okay. That will be by steps, okay? 11 and 6. Or it is 6 and 11. 2 respondents are the steps. All right.
Obliged, my lord.
Item 2.
May I please, Your Lordship? My lord,
Yes.
this matter pertains to the failure of appointment of new arbitrator by the respondent number 1 and 2. The fact of the case in brief is that the petitioner's land were acquired by award number 3 of 2019 for the purpose of construction of special railway project, namely Bairabi to Sairang, new BG railway line project in Aizawl district, Mizoram. Aggrieved by the said award, petitioners had filed an arbitration case number 3 of 2022 before the respondent number 5, that is the arbitrator, who concluded that the amount of compensation fixed by the respondent number 4 needed no revision. And then an application under Section 34 of the Arbitration and Conciliation Act 1996 for setting aside of the arbitral award was filed by the petitioner, which was registered as arbitration application number 10 of 2024, which was disposed by the Additional District and Sessions Judge 2. By
Where is it? Where's the award? Page number?
26, my lord, 26 to 34.
Award has already been passed, isn't it?
Yes, my lord.
On 4/6/2019,
Yes, my lord.
and you're filing the, what is this?
This is,
This is a writ petition.
yes, my lord, for appointment of new arbitrator.
Why?
Because respondent number 5, which was the old arbitrator, the previous arbitrator,
No, what is the provision otherwise? There is already an award. Then you have to challenge this award.
no, my lord. May I continue? An arbitration application was disposed by the additional district and sessions judge who remanded the matter back to the arbitrator. Respondent number 5.
Where is the remand order? Which order are you challenging? Page 26 is the award.
Yes, my lord.
After the award was passed, then what happened?
Application was filed before the additional and district sessions judge.
Where is that?
Page 81, my lord. 79. 79 to 103. If your lordship may kindly turn to page 102.
So it was remanded back.
Yes, my lord.
After that, what happened?
It was remanded back to the respondent number 5, who did not take any steps. And on the other hand, he had sent a letter to respondent number 3 requesting to appoint a new arbitrator in his place, but no appointment has been made till date.
Who is respondent number 3? Additional district judge or what?
The general manager. No
General
date.
manager.
Yes, my lord.
But arbitrator, it was remanded back to the same arbitrator, isn't it?
Yes, my lord.
And the arbitrator has not taken up the steps.
No, my lord.
So under such circumstance, what is the remedy available to you?
Our prayer is that this court may give direction to respondent number 1 and 2 to appoint a fresh arbitrator, a new arbitrator.
What seems to be the problem with the previous arbitrator?
Sorry, my lord.
What seems to be the problem with the earlier arbitrator.
He has already pensioned, my lord.
What was he?
Yes, retired.
Name? What is his name?
Dr. Lal Zirmoya Tsangte.
Oh. No, he maybe have retired. Arbitrators are mainly retired persons. But what is seems to be the problem? Why can't he take it up? Arbitration application was filed by you, the landowners.
Yes, my lord. There's also a similar case, my lord. There are
What-
other 3 pending writ petitions before this court.
So that was regarding the rate of,
No, my lord, for the appointment of,
no, your arbitration award 3 of 2019.
yes, my lord.
The decision was that market rate of at the rates of market value of additional land values and so, fixed by the district collector. So as fixed by the district collector, it was disposed of. So you were not happy with the award, the market rate.
Yes, my lord.
So you filed arbitration application.
Yes, my lord.
Then court said that it should be remanded back because the Act of 2013 will apply.
Yes, my lord.
All the components in 2013 Act will apply, should be given to them.
Yes, my lord.
But now that arbitrator is not functioning,
Yes, my lord.
your good name,
Vanal Monpui.
please write down. Hart Miss Vanlal Moanpui, learned counsel for the petitioners, who submits that the petitioners are owners of their respective land situated in Bairabi or Sairang. To stop. For the purpose of the special railway project, that is Bairabi-Sairang new BG railway line project, bracket 51.38 kilometers, comma, award number 3 of 2019. Dated 4/6/2019, was prepared by the respondent number 4. Stop. The petitioners not happy with the award preferred arbitration application number 10 of 2024 before the Additional District and Session Judge 2, Aizawl, under Section 34 of the Arbitration and Conciliation Act 1996. Stop. The same was disposed of by the court. Write judgment and order dated 24/4/2025 by remanding the matter back to the arbitrator for fresh adjudication, fresh determination in terms with the provisions of the right to fair compensation and transparency in land acquisition, comma, Rehabilitation and Resettlement Act, comma, 2013. Stop. According to the petitioner, although a copy of the judgment and order was forwarded to the arbitrator, Special Railways Project, but the arbitrator has not taken up the matter till date. No, did not take up the matter. And therefore, the petitioners till date, full stop. The rest you cut. And therefore, all that required, not required. Full stop. See, out here at page 107, the arbitrator has expressed his inability, isn't it?
Yes, my lord.
Full stop. The arbitrator has expressed his inability to continue as the arbitrator by writing a letter to the General Manager, Construction, NEF Railway on 13/5/2025. But since the latter has not taken any steps till date for appointment of a new arbitrator, some other petitioners are before this court. Next para, in view of above, issue notice of motion returnable by 4 weeks.
Lordship, I'll accept notice on behalf
Baby
of
Laldin
CGC
Zwali.
for respondent number 1, 2, and 3.
Ms. Baby Laldin Zwali, Lanet Council accepts notice on behalf of Ms. Zairem Sanghui, Lanet CGC, who will be representing respondent numbers 1, 2, and 3. Stop. Petitioners to take steps for service of notice upon respondent numbers 4 and 5 by registered post with ADU within 3 days. Extra copies of the writ petition be furnished to the respondents.
For orders, item 8.
May I please your lordship?
Yes.
Lordship, in item number 8, lordship, I am appearing for the petitioner. Here, lordship, the petitioner was arrested on 9/11/2024. As on date, lordship, the petitioner has completed 360 days, that is 11 months and 25 days. The fact of the case is that, lordship may kindly come to the FIR, that is at page number 17. In the FIR, the petitioner is named and he is the only person against whom the case is registered.
Just a minute. Do you have the case diary? Who has the case diary? PP?
Your Lordship, in this matter, Mrs. Vanessiami is representing the state. However, she's on legs, Your Lordship.
Does she have the case diary with her? Scanned copy?
May I just take in instructions in that regard, Your Lordship? I do not.
Yes, just wait. Let us wait and see. The counsel is on legs in a different court.
My lord,
We'll pass it over for the timing.
my lord.
Just find out whether she has the instructions with her so that we can take up the matter.
Yes.
Next matter.
Item 9.
Yes, 9.
Your Lordship, this is an application for condonation of delays of 680 days. However, it is 148 days from the date of acknowledgement and only 1 day after issuance of CTC. And my Lord, the ground of delay can be explained in detail through list of dates as mentioned in page number 5 of my application. List of dates, page number 5.
Okay, just a minute. Who is appearing for the opposite party?
I'm appearing.
Any objection?
Yes, my lord.
You have filed objection.
Yes, my lord.
Okay, we'll hear you then. Let me hear the applicant first. Where is your application for condonation of delay?
Already submitted, my lord.
Delay of 680.
680 days, yes.
What is your explanation?
My lord, in fact, I'm the legal occupant of the disputed building, and I lawfully occupied the premises since 2022 uninterruptedly. However, the respondent, who is my stepmother, secretly obtained airship certificate without inviting objection and newspaper publications. And I came to know the existence of the airship only on 24/2/2025 through the receipt of information through RTI.
Where is that page? Where is your statement?
Statement, it is in my lord, page number 18 of my application.
80.
18. I came to know the existence of the impugned airship order only on receipt of the RTI reply.
No, I'm talking about the statement, not your annexure.
My statement, my ground, it is in page number 8.
Paragraph number?
Paragraph number 5, sub number
No, but your information. When did you know the information? That is not there.
yeah, my through the RTI copy, because in the beginning of 2025 this year, it is mentioned in page number 9 and 10 of my application. Para number 5, sub number B. In the early 2025, the budget party demanded me to vacate my residence, stating that in imponitolo dan market in defecto. In English, this is no longer your house. Legally, it's my house. So, in order to know the conditions of my LSC, I applied RTI, and through the RTI, I came to know that the opposite party have fraudulently obtained airship certificate without inviting objection and a newspaper publication.
No, this fact you have come to know only in early part of 2025.
Yeah.
Early part means which part? Which month?
You receive around February, March, but I don't know the exact month. It is around February or March. And I received the RTI reply only on.
No. You just go in sequence. First of all, you tell me what is the property in dispute
Building
covered by?
covered by LSC number AN 740 of 1989. It's located at Chitevang, Aizol, Mizoram.
Just a minute. Where is the LSC? Have you mentioned anything about the LSC in your application?
My lord, LSC
You have not mentioned. Anyway, airship certificate you mentioned.
certificate, it is in page number, yeah. Certificate I mentioned, but I didn't have the original copy of the LSC, that's why I'm not able to produce.
You don't know the number also.
LSC number AN 740 of 1989.
You have not stated that anywhere. Only you have mentioned airship certificate order dated 12/6/2023. Correct?
My lord, I mentioned in list, I mentioned in,
It's all right. You don't worry too much about that.
in page number 5, I mentioned.
Don't worry too much about that. Now, airship certificate order dated 12/6/23. Correct?
My lord, yes.
2023.
My lord, yes.
Now, you became aware about this heirship certificate only in the early part of 2025.
My lord, yes.
Then immediately, what did you do?
Immediately, I filed appeal before the District and Session Court on 4/3/2025.
Appeal.
Appeal, yeah. Appeal of heirship certificate before the District and Session Court,
When did you file?
4th March 2025.
No, before that, you have done something else.
Before
You just now said that you had filed some RTI application.
yeah, on 24th, 2nd, 2025,
Ah.
I received the reply of RTI on 4th.
When did you submit the RTI?
My RTI application has been submitted on February 2025, and I received the reply on 24th February 2025 within the month itself.
So, after learning about the existence of heirship certificate, you submitted RTI application.
On knowing that the opposite party had already, knowing that the opposite party intend to evict the building, and also they demanded to vacate the premises on January 2025. So inquiry, I applied RTI application to the Revenue Department, and I received the reply of RTI on 24th February 2025.
Okay, then
And immediately after knowing the existence of the heirship certificate, on 4th March 2025, I filed memorandum of appeal before the Court of District Assessment Judge. However, it was rejected because the suit value is exact 10 lakhs, not less than 10 lakhs, exact 10 lakhs. That's why it was rejected. And the
just a minute. Go slow. Rejected on which date? Because I need the facts and figures.
it was rejected on
Your
2/6/2000, June 2025.
2nd June.
2025, yes, my lord. It is mentioned on page number 23 of my application, the order, the rejection order.
What did you file? RFA
Yes, RFA.
number
RFA number 12 of 2025.
and along with condemnation application.
Yes, my lord.
What is the number? Nomenclature and number.
RFA 2025 and the condemnation application.
Order was passed in which case? In the RFA or in the condemnation application?
In the condemnation application.
So what is the number?
My lord, my sincere apology that I have not mentioned the
Delay was condoned or what?
not condemned because at the instant it was found out that there's a lacking of pecuniary jurisdiction. That's why it was,
Okay, without condoning the delay, straight away order was passed in the RFA.
yeah, it was rejected outright.
But at least you must be having you should be having the number of the, what do you call it, IA, interlocutory application
Yes, my
or
lord.
misapplication.
My sincere apology that I failed to annex in my application.
You fail to mention it also, the number.
Only the main petition I have mentioned. My lord, before hearing was conducted, it was rejected outright at the beginning, in knowing that it was lacking pecuniary jurisdiction.
So what order was passed in the delay condonation application? You don't have a copy of the order with you?
My lord, it is in page number 23. Annexure 3.
No, this is RFA.
RFA before the district and session court.
I know that.
Yes.
This RFA was hit by delay, isn't it?
Yes, my
So
lord.
you file an application for coronation.
My lord, yes.
Where is the application? Where is the order?
There's no separate order. Only the main petition order. There was no separate order of miscellaneous application of condonation application.
But you filed miscellaneous application.
Yes, my lord. But there was no separate application. There was no separate order. Only the RFA order was passed, issued.
Is it so?
Yes, my lord. Because I
Come to page
I have
10.
not received.
Come to page 10. Paragraph C.
Yes.
Just read.
That upon discovering the existence of the airship certificate, the applicant promptly consulted legal counsel and filed the present appeal along with a condonation application before the district and session judge Aizawl Judicial District on 4th March 2025, registered as regular first appeal number 12 of 2025.
And what about that condonation of delay application? Not registered.
My lord, but I do not receive any order because I applied RTI and
No, even if you don't receive any order, at least you should tell us the number of that IA. Today also you are seeking condonation of delay.
yes, my lord, yes.
Can we just say that there is one condonation of delay without any giving any name number? Process is same, whether it be the district court or whether it be the high court. If you're filing application beyond the period of limitation, you have to seek condonation. You have to file application. And if application was not registered and numbered, say so. If order was not passed, say so in your statement here. Now we don't have any information. You are saying I file application and you mention it as RFA. RFA is an appeal. You got my point?
Yes, my lord, yes, I got, but however, there's only a single order and there's no order, or no orders issued on the application, yes.
Then make a statement here. There is no order pass in the application, but only order passes in the RFA,
Yes, my
and
lord.
it was rejected on ground of jurisdiction. That you have not stated.
It's my sincere apology that
No, there is no question of apologizing like that. See, you are a lawyer, you are an advocate, practicing advocate. You should know how things are mentioned. You should go meticulously in a chronological order, because this is not a writ petition or this is not an appeal which you are filing without delay. You are seeking condonation of delay. So you are supposed to at least make your application presentable with satisfactory explanation that delay was caused due to bona fide reasons and not for any other malified reason. So you have to be meticulous. Unless you create that impression to the court, court will not condone the delay, even if it's for 50 days or 40 days. This is very important. You should keep that in mind. And today you are seeking condonation of 680 days.
My lord, in page number 21,
And you should also know from your client, when did you come to know about this heirship certificate? Definitely they will say in the month of, probably in January, February, or maybe in the early month of March, whatever, like that.
my lord, as far as information I received, they are not clear. And what they said is in the beginning of January or February, they are not
So
certain.
that is why you have to help them to make it clear. Because you say that you file RTI application.
On,
RTI application you file in February.
Yes,
That
ma'am.
means your knowledge was maybe in January or February.
yes.
So that way you can take the hint from there. Or without knowing that there was a heirship certificate, you applied for RTI. Is it like that?
Yes. Because in order to prove whether airship certificate was already existed or not.
So after RTI reply was given, you came to know.
Yes, my lord.
Rejected on 2/6/2025.
Yes.
Thereafter, what did you do?
Thereafter, on 5th June 2025, I applied certificate to CTC in respect of RFA number 12 of 2025, as well as airship certificate number 835 of 2023. And the CTC copy was issued on 16 June 2025. However, there was a mistake in the issuance of the CTC. So the CTC copy was reissued on 21st July 2025. And immediately after receiving the CTC copy, after 1 day, I filed the present IA along with the RFA petition. So, my lord, my ground is there's no negligence or carelessness on my part, and it is beyond my control. So, I humbly pray your lordship indulgence and leniency to condone 60 days of delay.
So ultimately, the corrected certified copy was given to you on 23/7.
Yes, my lord. And after 1 day of receiving the certified true copy, I had filed the appeal, the IA along with the member of appeal.
On which date? One day means what? Which date?
1 day is 22nd July 2025.
That means 1 day before giving certified copy, you filed the appeal. Page 11, the second paragraph, somewhere in the middle, you've written, applicant reapplied CTC and was granted on 23/7. And you say that you file appeal on 22/7, 1 day before.
Since that there's also still a mistake in the CTC copy. Because the fact is, CTC has been issued on 20, CTC, there's still a mistake
What is the mistake?
because, in fact, the CTC was issued on 21st July 2025.
Where have you written that?
It is 25 July 2025. Yes, I have mentioned in page number 5 of my application.
From where are you saying that? Sometimes you're saying 21st, sometimes you're saying 25.
On 21st, because Your Lordship, I am certain that on 21st July 2025, which is also my birthday, I have received the CTC copy. And after 1 day of issuance of receiving of the CTC copy, I have filed the appeal.
CTC of which copy?
RFA 12 of 2025.
Come to page 20. Page 20. Are you at page 20? Annexure 3, page 20.
Or CTC of airship certificate, the impugned airship certificate order.
RFA is received on 16/6/25.
6/6/25, and the airship impugned order was received on 21st July 2025. And it seems that there's a mistake in the mention of that in the impugned airship certificate order.
Where have you stated that in your application?
In my application, Your Lordship, I have not.
Then you are submitting which is not stated in your application. How do we expect to go to respond to that? You may say anything you like, which is not written in the application. Should we accept that?
My lord, I prayed at least 1 week to check the CTC and to compare with my application. I am prepared to have one more weeks to compare the CTC and my application. It seems that there's some error in the date or in the mix-up. There's some mix-up.
Already you are delayed by how many days?
680 days, yes.
Huh?
680 days.
18 days.
680 days, counting from the issuance of airship certificate order.
680
80.
days.
Yes.
Then in your paragraph number 4, you have written 770 days delay.
After minusing 90 days, the statutory period of limitation.
Your application is poorly drafted. Well, this is all I can say. I'll give you one opportunity to file an additional affidavit. File it meticulously
Duly obliged, my lord.
by giving the chronological how you have arrived today, from date of heirship certificate till today. Chronological.
Duly obliged.
Otherwise, don't expect this court to consider their application in such a manner. It will be difficult. As prayed for by Mr.
K. Ramanwatfela.
K. Ramanwatfela, learned counsel for the applicant, appellant. A week's time is granted for filing additional affidavit to provide for the chronological to state to explain chronologically the list of events, that is, i.e., from the date of knowledge about the heirship certificate till the filing of the instant application. List again after 1 week.
Obliged, my lord.
Duly obliged.
Item 8.
Your Lordship, I would like to tender my gratitude in accommodating me for my lack of instructions in the matter, Your Lordship.
No problem. So,
Your Lordship, my learned friend on obtaining the instructions, my learned friend is yet to get the scanned copy from the concerned officials. So if this matter can be passed over for the day or any day convenient.
but when can she get the scanned copy? Depending on that, we'll fix the date. Otherwise, there's no point in fixing the date like
Your
just like
Lordship,
that.
since this is ISOL, I think they will be able to get it within a day, the scanned copy.
Scanned copy.
Yes.
Yes, Mr. Counsel,
My lord, otherwise the scanned copies would be relevant, lordship, as because lordship, the grounds on which I am seeking bail, lordship, scanned copies are very much essential, lordship, in this case.
we'll do one thing. We'll list it on Monday next
My lord.
as fixed item. Today's what? Today's third.
Today is 3rd.
List the matter on 10th of November 2025 in the admission column. Full stop.
obliged.
Ms. Vanesiami, learned additional public prosecutor, appearing for the state, shall secure the shall secure scanned copy of the records on that day. Records and produce the same on that day for perusal of the court. Please inform her to get it, okay?
Item 10.
Alia.
My lord, in this matter, notice was initially sent through register post to the AD to the respondent number 7, 8, and 9, my lord. However, the same was returned unserved. And then after that, my lord, on the last court date, we were directed to serve by way of Dusty. And again, my lord, we have some problem because we could not locate the address given in the respondent number 7, 8, and 9, my lord.
Who are they?
7 is the first owner of the sumo. 8 is the second owner. 9 is the driver, my lord. And my lord, if I may be allowed to take steps by way of substituted service, my lord. Newspaper publication, my lord.
7, 8, and 9.
Yes, my lord. In the trial court, there was no representation, my lord.
Rank deal. Where is rank deal?
During the Mamit district, my lord.
Mamit district.
Yes.
In the tribunal, they did not contest
They have submitted WS by
Written
themselves. They
by
were-
themselves.
Yes, my lord.
Who are they otherwise?
The
What is their role?
7 is the first owner, my lord.
Then 8
8 is the second owner of the Mexicab.
and 9,
9 is the driver of the accident vehicle.
driver. Appellant is the
Appellant is the insurance company.
insurance company.
Yes, my lord.
You are for the insurance company.
Yes, my lord.
And
National insurance.
I'm for respondent number 1 to 6, my lord.
Claimant, my lord, before the
The
trial.
claimants.
liability has been fastened on whom? The insurance company.
Insurance, my lord.
Insurance company, my lord.
Why did you file the appeal?
Regarding that, there are 3 points, my lord, like contributory negligence and regarding the quantum and regarding the accident happened, my lord, like it was the claimant son made accident with the Mexican, my lord. On Zarkot, he hit one sumo. So from the police report, we thought that it would be contributory negligence, my lord.
It's a case of death.
Yes.
How much is awarded?
What is, my lord? So, 14 lakhs, my lord.
14.
Yes.
How much?
What, my lord? My lord.
All right, you. In which paper will you publish?
Banglaini and Aizol Post.
2 daily.
Yes.
Please write down. Notice has not been effected on respondent number 7, 8, and 9. Although the same was attempted by registered post with AD due as well as by way of Dasti. Stop. Under the circumstance, the appellant is permitted to serve notice upon them in a substituted manner through newspaper publication. We'll stop. The applicant. This is appellant.
Appellant, yes.
Appellant.
National insurance.
The appellants shall cause newspaper publication in 2 local dailies for 2 consecutive days. To notify the respondent number 7 and 8 about the pendency of this case.
9, my lord. 8,
7,
7,
8,
8,
9.
9.
I'm sorry, 7 and 8 and 9
Yes.
through the registry of this court. Stop. The publication should be done on or before How long will it take?
Within this week, my lord.
Within, huh?
Within this week, my lord. Make
Should be done.
application.
By 12th of November 2025. Showing the next date, showing the next court date as 20/11/2025. Stop. The appellants shall file an affidavit incorporating the newspaper application by 14th of November 2025. List accordingly. Okay.
Right.
Item 11.
One more line. Mr. Benjamin Lalthamona, Learned Counsel, appears for the respondent number
1 to 6.
1 to 6. Okay.
Item 11.
May I please, your lordship?
Yes.
Yes, my lord, this is an appeal against an impugned judgment or an order passed in eviction suit, in which I was a defendant in that eviction suit and I was directed to vacate the land within 3 months from passing the judgment and order.
Yes.
And an execution case has also been filed by the respondent before the executing court. And
Okay. Why is it listed today?
as per the last court date, my lord, I have submitted that the execution petition. I only learned about the execution petition on 30th of January 2025. Only after this appeal has been filed. But according to the respondent, the execution was already filed way before December. So TCR was called upon on the last court date.
Okay. So paper book is required or not?
No, my lord.
Lordship, may I? Yes, in the last court that my learned friend had stated that they doesn't receive any summon with regard to that execution case. I am submitting that we have duly served that summon. Between that controversy, that LCR was called by your lordship. That is the reason.
TCR is there? Oh, we list it for hearing then.
Yes, yes, my lord.
After a week?
My lord, I am also ready today if
Huh?
I'm
Today is
also
listed
ready.
for orders. That's
Yes.
why I'm saying. Parties are represented by the respective councils. And it is also seen that the TCR has been duly received. Stop. In view of above, list the matter for hearing after a week.
Obliged, lordship.
Yes.
Item 12.
Please, Your Lordship, the
Masnir has some personal difficulty if the matter can be taken up tomorrow.
Okay, list again tomorrow as paid for. Give the date.
Item 14.
May I please, my lord? Lordship, as per the office note dated 30/10/2025, adequate or unserved notice is not returned yet from the sole respondents. So if I may be allowed to take step by way of the stay.
On which respondent?
Sole respondent, my lord.
What is the address?
Didn't her.
Aizawl.
Yes, my lord.
Okay.
Hello, we went her.
Since notice has not been served upon respondent number, sole respondent, despite steps having been taken, the applicant is permitted to serve notice by way of Dasti through the registry of this court within 10 days. The applicant shall thereafter file an affidavit as proof of service. Not as, you write an affidavit to show proof of service.
Deeply obliged.
List again after 10 days.
Item 15.
Yes, Mr. Zekima?
My lord, we have, by filing the instant IA, we have prayed this honorable court for amendment of the appeal, my lord. My
What is the
appeal,
amendment?
My lord, the operative portion is at page number 4, paragraph number 3. In the IA.
What is this, a ground?
Yes, my lord, a ground, which is,
You want to insert a new ground?
yes,
Or-
my lord. This basically is a question of law, my lord. This is pure question of law.
Oh, this is a modified ground or a new ground?
New ground, my lord.
New ground. You want to add this?
Yes, my lord.
Yes, who's appearing for the Zoram Sana?
Yes, my lord.
Any objection?
No, my lord, I will not be filing the objection.
And Mary? No. Okay, heard Mr. T. Lal Zakima, learned counsel for the applicant, who submits that by filing this application, the applicant seeks addition of one more ground as ground number small Roman 6 in the connected FAO, which is stated in paragraph number 3 of the instant application. Stop. The learned counsel submits that the ground taken is on the point of law and will not change the nature and character of the FAO. Stop. Next para, Mr. Zoram Chana, learned counsel, appearing for the respondent number 1, and Ms. Mary L. Kiante, learned government advocate, appearing for the state, submit that they have no objection to the application. Stop. Next para, in view of above, the application for
My lord, 1 and 2.
who?
I am for 1 and 2.
Okay, Zoram Sana for 1 and 2, okay? And application for amendment of the application, amendment of the FAO by inserting ground number bracket small Roman 6 is hereby allowed as prayed for. IA stands disposed of. Then you have to file one recast, I think.
Yes, my lord.
Next, in the main appeal, in view of the order passed today in IAC number 171 of 2025, the appellant shall file a recast appeal within
3 days, my lord.
within 3 days.
My lord.
Okay, within 3 days, by serving the copies to the learned counsels for the opposite party. List the matter again after a week. In the admission column,
My lord.
yes.
Yes, my lord.
Item 16.
May it please your lordship. This is an application for condoning the delay of 232 days.
How much?
232 days, my lord.
232.
Yes, my lord.
Okay.
In filing the connected MAC appeal.
MAC appeal.
Yes, my lord.
You are for the You're the claimant.
I am not for the claimant, my lord. I am the respondent before the tribunal. And I
Okay.
was directed to pay a sum of rupees 2,85,800 to the claimants.
Okay. Liability has been fastened upon you.
Yes, my lord.
You are the owner of the vehicle.
No, my lord, I am an insurance agent. However, the insurance policy was declared to be fake.
Okay. Yes. What do you say?
I will be accepting notice on behalf of the respondent number 1, who is the claimant in the
One.
MACT case, yes.
Then what about the others?
My lord, the respondent number 4, if I may be allowed to serve notice by way of trustee.
Okay, then 2 and 3.
2 and 3 by way of registered postman.
Okay, heard Mr. Zoram Chana, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 232 days delay in filing the connected appeal against the judgment and order dated 4/12/2024, passed by the presiding officer, MSCT Aizol, in MSCT case number 22 of 2020. Next para, issue notice, returnable by 3 weeks. Miss
H. Lerausangi.
H.
Lerausangi.
Lalrosangi, learned counsel, submits that she has instructions to appear on behalf of respondent number 1. Stop. Therefore, notice upon respondent number 1 is waived. Before notice, you just write formal notice. Formal notice upon respondent number 1 is waived. Stop. Petitioner, applicant shall furnish requisite copies of the copy of the application as well as the memo of appeal to the learned counsel within 2 days. Next para. Applicant shall take steps for service of notice upon respondent number 2 and 3 by registered post with AD due within 3 days. Next para. Applicant is allowed to serve notice upon respondent number 4 by way of Dasti through the registry of this court within 1 week, and thereafter file an affidavit to show proof of service. List the matter again after 3 weeks. Respondents would be at liberty to file their objection. In the meantime, if so advised.
Obliged, my lord.
For admission. Item 3.
May it please your lordship, this is RFA number 54 of 2024, arising out of civil suit number 24 of 2020, referred against the impugned order dated 29/4/2024, wherein the learned civil judge has erred in dismissing the civil suit at the very threshold, that is at the first hearing without framing any issues, my lord. So, your lordship, the subject matter of the case is custodial death of the appellant's son. He was apprehended on 11/9/2024 and on 11th April 2014, and he fell from the premises of the Bongbong police station and was declared dead. And no inquest or no magisterial inquest or judicial inquest nor post-mortem examination was conducted on the deceased. So, your lordship, and the dismissal of the civil suit at the very first hearing is a procedural irregularity, since question of limitation is also a question of law and fact. And until and unless trial is conducted or evidence is adduced, the plea of limitation cannot be summarily applied without trial, your lordship. And also
What was this suit about? Claiming compensation.
compensation.
Have you annexed the suit?
Yes, your lordship.
Page
It's
number?
in page number 16 onwards.
16 onwards.
Yes.
Who is the defendant number 1?
Your Lordship, this is the stepfather of the deceased. He was striked out in the IA, that is in the last court. Because he has already passed away, and there is no legal representative from his family. No one is willing to participate
No, struck off in this appeal
in the IA.
in the IA. Okay, now I'm talking about the suit itself. In the suit, you have made him a defendant number 1, R. Zonun, Tluanga.
Yes, Your Lordship.
Why is he made a party?
Because he, during that time, as alleged by the respondent number 5, he was the one to give no objection regarding the post-mortem examination. Even though it is mandatory to conduct such examination despite objection from the family members.
No,
However, he has
who is
already
he?
passed away.
Who is he? He's the father,
Stepfather.
stepfather of the plaintiff.
He's the stepfather of the deceased, that is the ex-husband of the appellant.
And who's the plaintiff?
The plaintiff is the deceased mother.
So, plaintiff and this Zonun, Tluanga, they are the husband, wife?
Yes, Your Lordship.
So why did he make him a party? Does he have any contribution
No,
to the death?
since it was alleged by the respondents number 5 that he was the one to give no objection, therefore we just made him as a proper party. Actually, Your Lordship, no
Respondent
relief
number
was
5
sought.
means
Respondent number 5 is the OC, Bongo
OC.
Police Station.
he gave no objection to the postmortem.
Yes, Your Lordship, as alleged by the respondent number 5.
So?
However, there is no document to prove that.
You did not want the postmortem.
Yes, that is what the respondent number 5 has alleged.
See, your suit is for claiming some payment of some compensation.
Yes, Your Lordship.
Correct.
Yes, Your Lordship.
Are you saying that the father also should pay the money?
No relief is sought from him, Your Lordship. He's not a necessary party, but just a proper party, Your Lordship. So even if the respondent number 1 is strike off from the suit, Your Lordship, the matter could be taken up in his absence.
So civil suit was filed.
Yes, Your
Then what happened after that?
Civil suit was filed, but on the ground of limitation, the civil suit was dismissed. But
No, this civil suit is of the year 2020.
2020, Your Lordship.
Come to page 16.
Yes.
It was dismissed when?
It was dismissed on
29
29/4/2024.
After 4 years.
Yes.
So what was happening for 4 years then?
Your Lordship, this was taken up by a separate council, but as can be seen from the order, that is in page A, B, C, listed under A, B, C. The order is given there, Your Lordship. The suit.
No, you should not submit like that. By different council, I was not there. I don't know who was the council. That is not the way.
Yes, sir.
When you take up the brief, you have to find out the history.
Yes, sir.
Who all had dealt with the matter. And simply saying that I was not the council is not an explanation. You have to explain. You may say that I was not the council at that relevant time, but this is what had happened. So that explanation has to come from you. All right. And that explanation you will find out from the previous council or you will find out from your client. So putting the blame on the previous council just like that is not the way of submission. You have to find out the reason behind and tell us. See, page 16 is the civil suit.
Yes.
Now, any WS filed?
Yes, Your Lordship.
Where is that?
It is in page number 36 onwards.
76,
36.
36. चलो हम बुलाएगा चले 36. WS filed by whom? Which defendant?
The state, respondent number 225. Respondent number 1,
They have not bothered mentioning defendant number so and so, just simply defendant. Defendant number 1 is not the state. Isn't it?
yes, Your-
One is a private person.
yes.
Maintainability and all those things have been raised. Thereafter, then what happened?
Thereafter, it was fixed for pre-hearing, and then on that day itself, the suit was dismissed.
Pre-hearing when?
Pre-hearing was fixed on 29/4/2024.
WS was filed on which date?
WS was filed on
There's no date.
no date, Your Lordship.
But month November 23.
Yes.
When was the civil suit filed?
Civil suit was filed
13
on
March.
23rd October 2017. Your Lordship, previously civil suit number 116 of 2017 was filed on 23rd October 2017. However, an application was filed under Order 23, Rule 1, read with Section 151, and then it was granted. And later, the civil suit number 24 of 2020 was filed. That is in page 16, Your Lordship.
16th I've seen.
Yes.
Before this, what is the civil suit filed?
Civil suit number 116 of 2017.
Have you mentioned anywhere in appeal?
Yes, Your Lordship.
Paragraph?
Under page number 6, Roman number 7, paragraph number 7.
Roman number 7?
Yes, Your Lordship.
Okay.
Page 6.
Where was it withdrawn?
It was withdrawn, the order, no, there's no clear mentioning on why, but the Order 23 was reflected, that is to withdraw with liberty to file a fresh.
Okay, withdraw with liberty. Then this suit of 24 of 2020 was filed.
Yes,
And that was sometime in the month of,
month of,
no, the affidavit is signed on 13 March
yes,
2020.
yes,
Then WS filed after 3 years
yes, Your Lordship.
on sometime in November 2023. Thereafter, the order was passed,
Yes.
pre-hearing. It was dismissed on which ground?
On the
On what
ground
ground?
of limitation,
Limitation means,
because under Order 23, Rule 2, which reads, if I may read it out, Your Lordship, in any fresh suit instituted on permission granted under the last proceeding rule, the plaintiff shall be bound by the law of limitation in the same manner as if the first suit had not been instituted.
order,
Order 23, Rule 2.
23 rule 2. Order 23.
Yes, Your Lordship.
Okay, rule 2. Okay, rule 2. Limitation of law not affected by first suit. In any fresh suit instituted on permission granted shall be bound by law of limitation in the same manner as if the first suit had not been instituted. That's it. So,
Your Lordship, if I may point out that since the subject matter concerns custodial debt, it is a continuing wrong. So,
So the first suit was filed in 2017.
yes, Your Lordship,
Next suit was filed in 2020.
2020.
So you have to explain from 2017. Now, what is the limitation prescribed
The limitation,
for filing a suit of that type?
3 years,
3 years.
yes.
So what is the explanation for that?
Your Lordship, the limitation, since it is a continuing wrong, since the subject matter is concerned with the custodial debt of the son, therefore, until and unless evidence is adduced or trial is conducted,
Prima facie, what is the material to show that it was a custodial death?
it is given in page number, actually, the respondent number 5 has also registered the case under unnatural death, which is in page number.
Cause of action arises in which date?
On 11 April 2014.
Death. That is the date of death.
Yes, Your Lordship, that's certificate.
11 April.
Yes, Your Lordship, 11 April 2014. Annexure 1D, page 30, I have attached the death certificate.
So your suit was in time,
Yes, Your Lordship.
suit of 2017.
Yes, Your Lordship.
But then again, you withdrew the same. When was it withdrawn? 38.
30, yes, Your Lordship.
Then why did you file after 2 years?
Because there was an ongoing talk between the respondents, Your Lordship, and since they could not make any settlement,
Which respondent?
the state, a verbal communication was made between them outside the court, Your Lordship.
Is that your statement anywhere in your complaint?
No, Your Lordship.
Then how do you bring in those things of the record?
Your Lordship, if I may take you to page number 29, the officer in charge of the Bongkon police station has also registered the case under unnatural death, which
29.
is in page number 29.
When was it registered? 2014.
Yes, Your Lordship.
Okay, this is one thing, but you are saying that there was ongoing talk for which you did not file the suit after withdrawing it.
Yes.
Coming to page 16 onwards, where have you stated that there was ongoing talk?
Nowhere, Your Lordship.
Then? So, what is wrong in the order then?
Your Lordship, since
It's like a fresh suit.
the question of limitation could only be established after determining, after framing of issues, Your Lordship. So until and unless issues are
Okay,
framed.
if issues are to be framed, there has to be some indication in your suit also that this is the problem we had.
Ye-
We could not file because of this or that problem. Although cause of action arose in 2014, we had withdrawn it because of this. Then there was ongoing talk, nothing fructified, so we have filed this suit. So anything in that suit in which you have filed, which is to that direction?
Yes, notice under section 80 was also given on 11th August 2015, which
No,
is
notice is not something else.
31 to 30.
My question to you is something else. I'm not asking you about the notice. I'm asking you whether you have mentioned anything like that, that for the reasons that you could not file within as soon as possible after withdrawing it.
No, Your Lordship.
Then how do you expect the court to frame the issues then?
Your Lordship, if I may take you to page number 18 and 19. 18 and 19.
Which
where-
para?
In para number 14 and 18.
Read.
That as the plaintiff and paragraph number 14, that as the plaintiff and her family are being deprived of their only means of livelihood, the plaintiff had earlier served a notice under section 80 of CPC to the defendants on 11th August 2015 for payment of compensation due to the custodial death of her son. However, the said notice remains undisposed till date even after the expiry of the stipulated period. And under paragraph number
No, you stop there for a moment. Stop there for a moment. Once you file that section 80 notice, what do you have to do? You just wait like that for all time to come. It is merely a warning to them that if you do not file, I will file a suit. So what stopped you from filing a suit? You want them to dispose of your 80 CPC notice? Not necessary. They may keep quiet, do nothing. You are not stopped from proceeding to file a suit. Isn't it? So you did so by filing suit in 2017. For reasons whatever best known to you, you have withdrawn in 2020. Thereafter, suddenly again in 2020, you filed the suit without mentioning that this is what had happened, so I could not file before that. Now come to paragraph 15. Cause of action arose in
11/4/2014 when the deceased Limpuya had died while he was in the Bongkon police station custody. Para 16, that the cause of action arose in Aizol and as such is Honorable Court has territorial jurisdiction to entertain and dispose of the present suit. And under paragraph number 18, that on 23rd October 2017, civil suit number 116 of 2017 was filed, and while the said case was in its early stage, it was withdrawn with the liberty to file a fresh right order passed by Honorable Senior Civil Judge 2, and therefore the instant case is filed afresh for a kind disposal of this on the court. So, Your Lordship, based on these paragraphs, it can be construed that an exemption for limitation has been mentioned, even though the specific provision, that is Order 7, Rule 6, is not mentioned. And also, since the matter is regarding custodial death, Your Lordship, the appellant deserves her day in court.
no custodial death has to be established.
Yes, it in page number 29, it has already been revealed that the death is an unnatural death, and it is also registered under UD case. UD case number 8 of 14, date 12/4/2014.
What has happened to this UD case?
UD case unnatural is since he was taken in the Bongkon police station on 11/4/2014. He fell from the premises from the Bongkon police station.
No, that is not what I'm asking you. This UD case has come to a logical conclusion.
Yes.
What is that?
At the very end, it is written there in page number 29, the last paragraph, that I therefore requested that a UD case be kindly registered regarding this incident as per law.
So after registration matters finish.
Yes. And also RTI is also applied, and the response was also.
So
given.
today you file your RFA before the High Court. After filing matters over,
No, Your
not required to be decided.
No, the appeal. If
Now, after UD case is registered, no further investigation is required.
it is re-
No report is to be prepared.
it is required,
Then-
that is not conducted. Therefore, that is why compensation was claimed in.
No,
the
you cannot obtain compensation just like that. You have a garden in Sairang. Today you submit application, give me compensation because train is running there. They'll give you compensation like that without verifying, without actually seeing. Same thing. So you are asking compensation. Why? Because there's custodial debt.
Yes.
What is the evidence? You say case is registered.
Yes.
UD case is registered. Merely registration of UD case doesn't mean that it was true that he died during in custody because of these reasons.
Yes.
So there has to be a report.
Yes, that is the reason why the suit, if not taken for trial or evidence is adduced, we cannot determine
You have to
whether,
file appropriate suit for seeking investigation. You have not done that. Simply you have gone for the money. Give me money because of this his death. Cannot be like that.
if your lordship permit, I would like to submit a ruling regarding compensation for custodial death.
Yes, please. What is the relevant portion? What is that?
Your lordship, this is, guidelines have been provided where in cases of unnatural death, that statutory duties has to be performed. And it was held that since in this case, that is in J.S. Verma, in Srimati Nilapati Behera alias Lalita Behera versus State of Orissa and other respondents, it was held that the mother of the deceased to be compensated for custodial death of the petitioner, which is given in paragraph number 35, that is in the last page, Your Lordship.
No, you don't go straight away to the conclusion.
Yes, and also
You are to explain what was the issue involved in this case
the issue in
and what was ultimately the decision of the court.
the issue involved is that the son was had died in police custody, and since no proper investigation was conducted, it was held that the appellant's mother be compensated, and also guidelines and since this custodial death also touches on the scope of fundamental right that is under Article 21.
So you come to page 3, paragraph 3. Read.
In view of the controversy relating to the cause of death of Suman Behera, a direction was given by this court on 4/3/1991 to the district judge Sundargarh in Orissa to hold an inquiry into the matter and submit a report. The parties were directed to appear before the district judge and lead the evidence on which they rely. Accordingly, evidence was led by the parties, and the district judge has submitted the inquiry report dated 4/1991 containing his finding based on that evidence that Suman Behera had died on account of multiple injuries inflicted on him while he was in police custody at the police outpost Cherai Kela. The correctness of this finding and report of the district judge being disputed by the respondents, the matter was examined afresh by us in the light of the objections raised to the inquiry report.
See, from what you have just read, I hope you understood
Yes.
that it was not merely somebody said that somebody died in custody, so given compensation. There was an inquiry which was done by the court. Court had directed inquiry to be made by the district judge. And the inquiry report was submitted. And then there was a dispute regarding the inquiry report also.
Yes.
Objection raised. So again, court also took the pain to look into all those matters.
Yes.
You can see meticulously paragraph number 5, everything has been examined. So how on earth do you expect that the court will allow your application and grant compensation at this stage?
Your Lordship,
Like that.
since the statutory duties has not been performed by the respondents, therefore it could not be established whether
Then you should have filed a writ petition saying that although you have registered an unnatural death case, but no further steps has been taken to conclude the investigation and submit the report. That's how you should have proceeded. Instead, you file a suit claiming compensation straight away, as if that everyone accepts that it's a fault on the part of the on the part of the investigating or on the part of the police that he died while in custody. Without evidence is not possible. And secondly, your suit, in fact, was barred by limitation. That was the foremost thing to be considered. You have not bothered to explain anything also in your application, in your suit.
since the limitation is a question of fact and law, Your Lordship, therefore,
Yes, there we go again, back to square one. Fact and law,
Yes.
fine. But at least give us some handle, give the court some handle in your plaint.
I have mentioned in the plaint that no post-mortem examination was conducted and no inquest was also conducted. So, which clearly suggests that this is a continuing wrong, Your Lordship.
Come to the impugned judgment order. Let's see what is the decision arrived at. It's a very short order. Just read it.
Yes, I will start from the beginning.
Counsel from the third para.
Counsel for the plaintiff submits that the suit filed on time, that is before 3 years from withdrawal of the previous suit. The plaintiff asks local standi against the defendants, and there is also cause of action against the defendants. The counsel further submitted that the suit has no infirmity and thereby praised the court to maintain the suit. On the other hand, the learned additional GA argued and submitted that the suit is barred by limitation. The cause of action arose on 11/4/2014 and not on the date when the first suit was withdrawn. Heard and perused reports. The deceased Lil Himpuya died on 11th April 2014, and the cause of action arose that day. The plaintiff filed the previous suit and withdrawn on 21/9/2018. Order 23 Rule 2 of CPC states, in any fresh suit instituted on permission granted under the last proceeding rule, the plaintiff shall be bound by the law of limitation in the same manner as if the first suit had not been instituted. In views the aforementioned provision of law, it is clear that the cause of action arose on 11/4/2014 and not on the date when the previous suit was withdrawn. Besides, the plaintiff did not apply for exemption from limitation of law as per Order 7, Rule 6 of CPC. In view of the above, this court holds the view that the suit is barred by law of limitation and cannot be proceeded further. Accordingly, the suit is dismissed.
So what is Order 7, Rule 6?
Order 7, Rule 6 is exemption for limitation.
Did you apply for that?
No, but
Why?
under paragraph number 14 and 18 of the plain, it can be construed that exemption is applied even though a specific mentioning of Order 7, Rule 6 is not given.
Under paragraph number 14 and 18.
14 and 18. The reason why it has been belatedly filed is summed up in paragraph number 14 and 18. Page number 6, page number 18 and 19. Not sure.
But you have not said anything. Why you are filing after so many days? No, that's your case.
Yes, Your Lordship.
Let me hear the other side. Ms. Mary?
This is the first time that the matter is listed, Your Lordship, the RFA. So notice has to be issued.
The first time.
Yes, Your Lordship, in the last court date, delay was condoned.
Do you have a copy of the RFA?
Yes, I have the copy. I have briefly gone through.
I thought we were going for admission hearing.
I was under the impression that this honorable court was hearing my learned friend on whether the case is to be admitted or not.
You will issue notice only. I'm not admitting it.
Yes.
See, what about number 1?
Number one, notice was issued on February 25, 2025, and then after that it was reissued again in the month of June.
No, that was in the IA, I think,
Yes,
not in the appeal.
not in the appeal.
So appeal also we
Only
have
in
to
the
issue.
IA.
Now, respondent number 1 is no more.
No. No
When?
more, he passed away.
When?
We don't have the death certificate because they are not willing to provide that to us. However, his daughter was contacted, Ming Pui, and also compliance affidavit was submitted on 3/7/25. And
Give me
since,
the IA. Compliance means in the IA.
yes, Your Lordship.
In the RFA, there's nothing.
Nothing.
At least you must be knowing the date when he expired.
No,
How can that be? He died secretly.
because they divorced due to this matter, Your Lordship, and they were not in good terms.
They may not be in good terms, but people cannot die secretly. They make announcement at the microphone in this part of the country. Everybody knows. What did you file in the IA regarding death?
Compliance affidavit on 3/7/2025 was submitted.
So what do you want to do regarding respondent number 1?
To strike off, if Your
Strike
Lordship,
off.
it's
All right. Heard Miss
Seal Pui.
Ceylon Pui, learned counsel for the appellant, who submits that this appeal is preferred against the order dated 29/4/2024, passed by the Court of Civil Judge, Senior Division 1, Aizawl, in civil suit number 24 of 2020, by which the suit was dismissed on a ground on account of being barred by limitation. Stop. The learned counsel submits that the learned trial court ought to have framed issues with regard to the point of limitation instead of dismissing the suit at the stage of pre-hearing. Next para, in view of above, issue notice returnable by 2 weeks. Ms. Mary L. Kiangte, learned government advocate, accepts notice on behalf of respondent numbers 2 to 5. Stop. Formal notice is therefore waived. Requisite copies of the memo of appeal be furnished to her within 2 days. Next para, the learned counsel for the appellant submits that respondent number 1 may be struck off from the arrayed party respondent in view of the fact that he has already expired and there are no legal representatives to represent him. Accordingly, respondent number 1 be struck off. Registry to do the needful. What is there in the suit? Anything? WS and all that?
Yes, in the suit, written statement is also,
You annexed it, isn't it?
yes,
Nothing else is there, isn't it? Except for the WS.
no,
So TCR is not required?
it's required, Your Lordship,
TCR is required.
yes.
Registry to requisition to TCR.
Your Lordship, in the meantime, with the striking out of respondent number 1, my Lord Friend will have to file the amended cost
They're
type.
not required. Just strike off. If somebody was to be impleaded, then I would have asked her. But this is just striking off.
Okay.
There'll be a, what do you call, note from the thing, from the registry, as that it was struck off by order date and so and so. That will be done.
Okay.
List after 2 weeks along with the TCR.
Much.
Item 4.
Acha, what time is it now? I'll just take a 5 minutes break and come back. Okay, call the Jamadar.
May it please your lordship.
Yes.
My lord, by filing the instant revision petition, we are challenging the order 2609/2023. This is at page number 17, Annex 2, passed by the executing court. Our grievance is that, my lord, the learned executing court had wrongly interpreted the award of the Lok Adalat, which has been reached by the instant petitioner as well as the respondent herein. The Lok Adalat award, my lord, this is at page number 14, Annex 1. This is in the vernacular. And page number 15 is the English translated version. Even though we have made an English translation of the Lok Adalat settlement, my lord.
No, what are you challenging?
My lord, we felt that the executing court had wrongly misinterpreted the Lok Adalat award.
Where's the award?
The Lok Adalat award is at page number 14, 1-4. And page number 15 is a version of our version of the English translation. However, my lord, we have prayed this honorable court that the registry of this honorable court may make a translation for the ends of justice as well as fair play. Because our grievance is only that the learned executing court had wrongly misinterpreted this Lok Adalat award.
Okay, let us see what is written in the award.
Page number 14 is the vernacular. My lord, should I read the vernacular or the English translated version? Translated by the registry of this honorable court.
You can read the vernacular.
My lord. Terms of settlement. Parties panite puda thua male pulal tranpuyete an local veve in rem na hetiang hian kan siam puda thua matihian in hunchu cheng noi khat singa in pulal tranpuyete in leihi an rem ti a pulal tranpuyete hian cheng singa pe phot turin an in rem siama he cheng singa hi thlani chunga pek turati ani cheng singa pek ve le hian puda thua matihian LSC hi pulal tranpuyete hnena an pe anga apak cheng noi khat hi lon la ka jun thlavela in peturin anin soirema ma se har sanna ingemo a ompal ani chuan pulal tranpuyete hian puda thua mate hi an hril hrezel anga arem changang lo ani chuan kum sang ni som chungin pek tlak ram tur ni se he noi ka thi an petla theilo ani chuan LSC hi puda thua mate hian an ala let le theyang hei hi kan thin lung taka hei hi kan thin lung taka in rem na kan siam ani and the date is given.
The land belongs to whom?
My lord, the
Darthuama.
yes,
Land belongs to Darthuama and purchaser is Lalchanpuya.
my lord,
And today CRP is filed by the purchaser.
my lord. In fact, my lord, during insurgency period, the instant petitioner herein was initially a villager of Bero village near Zemabo.
So what is that got to do with this case?
My lord, this that brief facts will determine the
Okay,
controversy, my lord.
before you tell me the brief facts,
Yes,
what we understand from the term of settlement
yes, my lord.
is that Darthuama will sell his land to Lalchanpuya
Yes,
for a sum of rupees 1.5 lakhs.
yes,
Initially, rupees 50 lakhs will be given.
yes,
Within 2 months.
my lord.
Thereafter, they will pay the remaining by taking loan.
Yes,
If the amount is not paid, they will take back the LSC. They have the right to take back the LSC.
yes, my lord.
The amount has to be paid within the year of 2010.
Yes,
That much, isn't it?
that much. And
So why that translation was required?
because, my lord, in the
Or why the misinterpretation,
my lord,
according to you?
yes, in the impugn order, if your lordship could kindly come to page number 18A,
Ah,
18A, paragraph 5. With your lordship permission, I will read
yes.
fourth paragraph. Heard both parties at length.
Who filed the execution?
Execution has been filed by the respondent, my lord.
Wife of the
Yes,
Darthuama,
yes,
owner of that land.
yes, my lord.
Okay. But both parties?
Peruse materials on record. It is well settled law that the executing court cannot go beyond the decree. Now, in the instant case, the basis on which execution petition is filed is the award of Lok Adalat. The Lok Adalat award was executed between the judgment debtor and the husband of the decree holder, wherein it is stated that the judgment debtor was to purchase a plot of land belonging to the decree holder for a sum of rupees 1,50,000, of which it was to be paid in 2 installments of rupees 50,000 and rupees 1 lakh. The final installment of rupees 1 lakh was to be paid within the year 2010, and that the failure on the part of the judgment debtor to pay the agreed amount shall result in repossession of the landed property by the decree holder, which is to be sold to the judgment debtor. While the award of the Lok Adalat stands firm, the judgment debtor had failed to fulfill his part of the agreement in payment of the agreed sum of rupees 1,50,000. Although the written objection reflects attempt made by the judgment debtor to repay the amount and their willingness to pay even now, fact remains that the said amount was not paid within the stipulated period, and therefore the decree holder has all the authority vested upon him by the Lok Adalat award for repossession of the property which was agreed to be sold to the judgment debtor. Therefore, it is immaterial as to whether or not the judgment debtor is willing to pay the amount of rupees 1,50,000 at this stage, because of the fact that he has forsaken his right to own the property of the decree holder by payment of rupees 1,50,000 to him immediately on the expiry of the year 2010. Now, my lord, as per our understanding, the executing court had held that the period for payment of the amount is 2010, not after that. However, your lordship will see the terms of the settlement that efforts will be made that the whole amount will be paid during the year 2010.
So
That is why, my lord, we felt that the learned executing court had misinterpreted the terms of the.
Please come again. Which part is the misinterpretation?
Your Lordship will find at page number 18A, from the 10th line, paragraph A from the 10th line.
18A,
Yes, my Lord.
paragraph 5.
Paragraph 5 from the 10th line. There is the amount of rupees 1 lakh is written, and
Yes,
then
then?
the final installment of rupees 1 lakh was to be paid within the year 2010. Was to be paid.
Yes.
However, my Lord, as per the terms of the Lok Adalat settlement,
So, how is it to be understood, according to you?
my Lord, that efforts should be made to pay up the entire amount during the year 2010.
Yes.
So, and in fact, my Lord, it is not my case that I have not made an effort to pay the amount within the year 2010. In fact, if your Lordship will see at paragraph 4,
If you have not made an effort, then why didn't you pay then?
my Lord,
If you had made the effort?
yes, because the respondent herein had filed a title suit. The respondent herein was initially issued a periodic pata, which was a temporary pass, which was cancelled by the government. And one person had challenged the said cancellation order via this title suit number 24 of 1980.
No, periodic pata against which land? The same plot of land?
Yes, my Lord. Same protocol.
But did you take such kind of stand in your execution petition, in the execution petition?
We came to be aware of the title suit and the order passed in the same.
All right, but did you make that stand while the execution petition was pending?
Yes, my Lord. We have also submitted that we have made an effort to pay up the amount within the June 2010 twice. In the year 2010, we have made an effort to pay up the whole amount 2 times.
Then?
That was also reflected in the impugned.
Then what happened? The amount was not accepted?
No, my Lord.
Huh?
Yes, exactly. The respondent herein did not accept the amount, my Lord.
Anyway, come to the language part. You were just saying that misinterpretation.
My Lord.
Regarding the balance.
My Lord.
Abak cheng noi kat hi lon la ka jun tha vela in peturin anin soirama ma se har sadna engamo aom pal ani chuan pulal chan poe te hian puda thomate an hril zelanga arem chang ngang lawani chuan kum sang hi som chungin pek tlak ram tur ni se. So within 2010 it should be given, that's all.
Yes. And in fact, my Lord,
Where is the misinterpretation?
Ram Turni said it basically,
Okay, that means it gives you some liberty.
my Lord.
It
He
might,
said-
maybe
yes,
there'll be it's a liberal way of saying that.
my Lord.
Shram ni say,
Yes. And
okay.
also,
Now, regarding your contention about that suit and whatnot, you wanted to give money, they did not receive it. Where is that? It is not indicated in the execution case
no, my
order.
Lord. No.
Where did you state in your objection or whatever you
We
filed?
have come to learn of the title suit only after the respondent hearing had filed.
No, you're
the
saying will
affidavit.
not do. You have to tell me in the objection raised by you in the execution case,
Yes.
did you file any objection?
In the objection case, we have
Have you mentioned what you are saying now?
paragraph number 4, my Lord, page number 18. Page number 18, this has been reflected by the learned executing court. my Lord. If I may read, paragraph number 4, page number 18. The judgment debtor, through his counsel, submitted written objection to the execution application and stated inter alia that the judgment debtor's wife and his daughter twice tried to pay up the money as per a word of the Lok Adalat in the month of June 2010. However, on both occasions, the decree holder refused to receive the money, saying that he would have a discussion first with his family and inform the judgment debtor of the outcome. It is not my lord, it is not my case that I did not try to pay up the money.
That execution records are here.
No, my lord.
How many dates were there in the execution petition? Execution petition file, you have filed an objection. And yes, opposite party, you are there. What is your stand?
My lord,
They tried to pay you, did not receive it.
we denied that, and we have objected. They didn't try to pay the money.
Did you raise that in your execution?
My lord,
Reply to the objection, no. How did you deny it? Verbally?
yeah, orally.
Orally?
Yes, in the executing court.
If it's
So
orally in the executing court, then that your submission is not recorded here also.
Yes, it has not been reflected in the order.
Then how do we expect that?
My
You
lord,
may have or you may not have stated also.
my lord, I would like to take your lordships to page number 8 of the affidavit filed by the respondent, paragraph number 8,
Affidavit filed in
filed by the respondent herein, my lord.
where? In which case?
In this instant case, my lord, revision petition.
What does it say?
It paragraph number 8 subpara.
Read.
It is also pertinent to mention herein that the area oblique portion of land that is 24 by 12 square feet, which is meant to be sliced out as per memorandum dated so and settlement award dated 26/02/2010, was only the occupied portion of the land which with the house standing therein of the petitioner. However, the petitioner refused to accept the portion of the land meant to be sliced out, initially as mutually agreed upon previously, and further claim larger area portion of the respondent land with the same consideration amount which is not acceptable by the respondent. My lord, it is not the case, even though my learned friend had stated that they did not acknowledge, I have not made an attempt to pay up the money. However, it's clearly stated by the respondent here that I have made an award, the attempt to pay up the money. But that the respondent refused because he was willing to only slice out the portion of land that is 24 by 12 square feet, which is otherwise not as per the term of the settlement of the Lok Adalat award. The Lok Adalat award says that he will hand over the LSC. The Lok Adalat award does not provide any specific area. It says the whole LSC.
Lok Adalat award talks about LAC.
Yes, my lord.
Which LAC? No number, no name, nothing like that, just LAC.
My lord.
It could be any LAC.
My case, my lord, my case is that I had applied for issuance of LSC in the year 2009. However, on filing of an application, I was informed that the land where I have constructed my house was under the LSC of the respondent hearing.
No, what I was indicating is that the agreement on basis which the terms of settlement has been arrived at
Yes, madam.
should have in the ingredients LAC number so and so
Exactly. Madam.
with the located in so and so. Area may not be described. If it was described, well and good. Well, nothing. Only thing is mentioned is only LSC.
Yes.
It could be any LSC anywhere in Mizoram. This controversy would have come also, although nobody says that, but I'm telling you, that's why
My lord.
now they're trying to raise, he's trying to raise that controversy now. What I meant was 12 into 12 feet only, 24 into 12 feet, not beyond that.
My lord.
And you say that, no, I was given the LSC. Then he will say, which LSC? Then which LSC will you point out? Number, name, location is not there. So this is the kind of settlement done. Anyway, it's break time, so we'll meet again after post-lunch.
May I please, your lordship.
Yes.
So, my lord, my submission basically is that the learned executing court has erred in applying its own version, whereas the
Okay, what was available before the execution court was the application for execution
yes,
and objection.
yes,
And the respective parties were heard and
yes, my lord.
order was passed.
My lord.
Now, is there any scope for taking evidence in execution? Both sides.
My lord, that
You have CPC with you? CPC? Come to section 47. What does it provide for?
My lord, section 47 provides for questions to be determined by the court in executing a decrement.
Yes, what are the questions? Has this been followed?
So far as our knowledge, my lord, no.
Then in a execution petition, section 47 is the thing to be considered.
My lord.
Points for determination, then and how, what would be the other procedure? Now, in order 19, we have affidavits when something a particular fact or facts can be proved by way of an affidavit. Order 19, then order 21. Subject to what you all say, and upon an overall view, it appears that it was not just that simple execution thing which was required to, I mean, the agreement order, settlement order. Because you have your interpretation. What interpretation is one thing, but apart from that, your averment that you had tried to give the money on 2 occasions, but they said that no, we'll discuss this within the family and we'll think about it. They didn't take the money. And the other side also says that what we meant was in fact 24 by 12. We don't mean the entire thing. So these things has to be, somehow looked into. Although it is not a court for adjudicating the matter once again, but even an executing court has a duty to perform in terms of section 47. So such being the position, probably it should be revisited by the same court, parties be heard, and elaborate your submissions regarding what was transpired, what transpired. You cannot just orally say that, no, we went there and tried to give, we didn't take. At least put that in some form of an evidence, or at least you bring that fact before the court as may be required. You are Mr.
Tila Zekima, my lord.
Opposite party,
Ram Murmu.
Ram Murmu.
Yes.
What do you say, Mr. Murmu?
Yes, my lord. We have objected their statement that they are trying to pay the amount. So, that's
But
our-
you have also stated
yes,
some other thing, that
yes,
what we meant by that agreement is that 24 by 12
yes.
feet, not beyond that. House is standing there.
My lord, this Lok Adalat award is passed in accordance with the previous settlement, which I have stated in Remna, which is earlier being settled by the revenue officer, which I have annexed in my annexer 4, page 31. Is the vernacular, and translation 1 is in 32. Herein it is clearly stated that Mr. Lertrampuya, the petition, shall acquire only the occupied area.
Just push the screen a bit that side there. I can't see the PS also. No? Yes.
Yes.
See, without expressing anything on merit or otherwise, we remand it back for fresh consideration by the executing court. We'll fix a date of your appearance, and whatever stand you have to take, you take your stand accordingly. Let the executing court consider. Third, Mr. T. Lal Zekima, learned counsel for the petitioner, and Mr. Ram Murmu, learned counsel for the sole respondent. Stop. By filing this civil revision petition, under section 115 of the Code of Civil Procedure, 1908, bracket CPC, read with Article 227 of the Constitution of India, the petitioner prays for setting aside the order dated 26/9/2023, passed by the Court of Civil Judge Aizawl in execution case number 22 of 2020, arising out of Lok Adalat case number 37 of 2009. Of Mr. T. Lal Zekima, learned counsel for the petitioner, submits that although no timeline has been specified in the Lok Adalat award dated 26/2/2010, the executing court held that the petitioner has forsaken his right as per the Lok Adalat award for having failed to pay the settled amount within the year 2010. Stop. He submits that although stand taken by the petitioner before the executing court was that non-payment of the settled amount was on account of refusal on the part of the respondent to accept the payment. He thus submits that the impugn order should be set aside since the executing court has gone beyond the prescription of the Lok Adalat award. Next para, Mr. Ram Murmu, learned counsel for the respondent, on the other hand, submits that the respondent has denied the stand taken by the petitioner that an offer was made for payment of the balance amount of rupees 1 lakh. 50,000 was given already?
No, 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 my lord.
Not given?
Yes, the whole money has not been
Attempts,
given.
my lord.
Yes.
What did I say? Submits that. Balance sheet, strike out balance not required. For payment of the amount of rupees 1.5 lakhs to the respondent. He also submits that as per the agreement dated 11/11/2009 between the parties, the area oblique portion of land to be sliced out was 24 into 12 square feet. So, however, the petitioner refused to accept the agreement arrived at previously and claimed for larger portion of the land, which was not acceptable to the respondent. Subsequently, the respondent offered a larger area of 30 into 18 square feet for a considered amount of rupees 3 lakhs, which was refused by the petitioner. Therefore, it only appears that the petitioner was never willing to settle the matter amicably with the respondent and instead occupy the entire land illegally without paying any kind of without paying any kind of consideration for the same. Next para, having heard the learned counsel for the parties, this court is of the considered view that the claim of the petitioner that he had tried to pay the agreed sum of money on 2 occasions but was refused by the respondent has not received the consideration of the execution court. Stop. Likewise, the claim of the respondent that land was offered to be sold, land that was offered to be sold at rupees 1.5 lakhs was not the entire LSC, but only an area of land measuring 24 into 12 square feet. Stop. Therefore, having regard to the provision of section 47 of the CPC, read with Order 19 and 21 of the CPC, as well as the relevant provisions of the Evidence Act, it is found that it was incumbent upon the learned executing court to formulate the questions to be determined by the court executing the decree by applying the provisions set out in Order 19 and 21 CPC. Please read the sentence from the beginning. Read from the beginning the sentence. Full stop. The same having not been done, the matter is remanded back to the learned executing court for fresh consideration. In accordance with law. Stop. Since the parties are represented before this court, they are directed to appear before the learned executing court on, when can you appear? Next Monday?
My lord. My lord.
On 10 November 2025. Whereafter, the learned executing court shall proceed with the matter in accordance with law and bring the same to its logical conclusion.
My lord, one small submission.
Yes,
The learned executing court does not mention the number of court that has been designated to the executing court. It only says Miss Bobita in page number 17.
Okay,
who is
so-
no longer stationed in
so-
Aizawl.
huh?
Who is no longer stationed in Aizawl. Miss
So she must have been handling some particular court.
she is in Sampai. She's been stationed in Sampai.
No, the court here.
My lord, my lord.
Who is handling the court now?
Uh,
Any number, 1, 2, 3 like that?
yes, my lord, there are several numbers. So if
So which is the appropriate court?
the civil judge, one,
1.
yes, would be appropriate now.
You agree with that?
Yes,
Remanded back to learned executing court, I said, na? That is Court of Civil Judge, Roman 1, Aizawl. Then the last part. The impugn order dated 26/9/2023, passed by the learned civil judge, 1, in execution case number 22 of 2020 is hereby set aside.
deeply obliged.
Yes. Next case.
Item 5.
Please, Your Lordship. Your Lordship, the pleadings in this matter is complete. No. We each have filed a affidavit as well as the rejoinder affidavit, but Your Lordship, if this matter can be, if it's going to take some time, if this matter can be posted on some other day, Your Lordship.
Monday next.
Yes, Your Lordship.
Parties are represented by their respective counsels and they submit that pleadings are complete and the matter may be listed for admission hearing. Stop as prayed for, list the matter on 10th of November 2025 for admission hearing.
Deeply grateful, Mr. Blaise.
Item 6.
May I please, Your Lordship, this is a contempt petition. The respondent number 1 has been represented. Sorry.
So have you verified?
Yes, we are in the stage of verifying whether we have find a proper person of the respondent number 2, but respondent number 3, there are more than one deputy director.
So
My Lord, we'll be filing the appropriate application for employment of those persons.
how much time?
2 weeks time, my Lord.
Please write down. Mr. Lalsan Liana Kyangte, learned counsel for the petitioner, submits that the petitioners may be given further 2 weeks' time to verify the posts, to verify the persons holding the post described against respondent number 2 and 3. and thereafter to file an appropriate application for that improvement. Stop. Ms. Baby Laltin Zwali, Learned Counsel, appears for respondent number
2 and 3.
2 and 3. Then how are they appearing? 2 and 3 is to be verified. Then again,
My lord, they, in the earlier occasion, they have submitted one letter dated 26/8/2025, saying that these persons are not the proper person holding the post. But it appears that they have submitted a vacant memo.
for respondent number 2 and 3. Only 3 or 2 also. Please read the sentence. Mr. So-and-so. Next para, Ms. Baby Laltin Zwali, Learned Counsel, appearing for respondent number 2 and 3, has no objection. View of above, list again after 2 weeks.
Item 7.
May please your lordship, my lord, I will be filing my affidavit, my lord. So I'm seeking
Affidavit
3
in a
weeks,
position.
my lord.
You are the government advocate?
No, my lord. No more, my lord.
You know more.
No more.
Then you'll be appearing for which respondent?
For the sole respondent.
What matter is this? What kind of matter is this?
Uh,
Award.
Yes, Your Lordship. This is a situation where I had sent my representative just to inquire about the issue involved in the case. However, without my authorization, they just accepted the terms of settlement proposed by the Lok Adalat. They went beyond their authorization.
Okay, how much time?
I'm allowed 3 weeks, man.
3 weeks.
My lord.
Mr. Lal Fakoma, Learned Counsel for the petitioner, is present. Stop. Mr. Benjamin Lal Lamwana, Learned Counsel for the sole respondent,
My lord.
prays for and is granted further 3 weeks' time to file affidavit in opposition. List again after 3 weeks.
Obliged. And my lord, one more, another different item with regard to item number 10. my
No,
lord.
no. Before that, you have forgotten the important part. What have you forgotten? Interim order passed earlier shall continue till the next date of listing.
Obliged.
Now you tell me.
My lord, with regard to item number 10, my lord, this case was fixed for 2011, my lord. However, I have realized that I have some outstation engagement, my lord.
Item number 10.
My lord. So this may be kindly come up on the 27th, my lord, 11.
Have you informed the other side?
I can inform them, my lord.
You should. It's not you can. You should inform. Otherwise, they'll be having the impression that it will be listed on that date. Item 10, okay? You just check up. The date should be now, next date should be 27/11 instead of the previous one, okay?
Obliged, your lord.
For hearing, item 17.
Yes, what is this matter? RFA?
Yes, Lordship. Same order is at page 87 onwards, Lordship. What happened? Lordship, civil suit instituted by the appellant was dismissed by the Learned Trial Court for want of cause of action, basically. Order is at page 87, Lordship, onwards.
No, what case is this? What kind of case is this?
Yes, Lordship, civil suit, page 15 is my plaint.
No, before saying page number, tell me what kind of case is this?
Yes, case is that Lordship, appellant preferred a civil suit for recovery of 2 crores 38 lakhs and an odd amount from the respondent number 1, Lordship. Fact is that Lordship,
Appellant filed the
yes,
civil suit
civil suit,
for recovery of amount. some amount.
recovery of amount, Lordship, 2 crores 38 lakhs. And
Then?
after issuing notice, Lordship, defendant entered their appearance and filed their WS. In the WS, Lordship, present defendant number 1 taken plea that initially the power of attorney, he is the contractor, class 1 contractor, and got an handsome amount of work about 8 crores, Lordship. And power of attorney was issued for the execution of the work in favor of the defendant number 2. Power of attorney was issued, Lordship. Power of attorney was issued on 12/1/2021 for execution of this work, Lordship. And this defendant number 2, 1 issued power of attorney in favor of defendant number 2. Defendant number 2 execute another power of attorney in favor of the plaintiff, Lordship, for execution of this work. Now they have taken plea that after 2 years, after almost at the end of the completion of the work, defendant number 1 taken plea that no, he has not authorized the defendant number 2 to subdelegate power of execution in favor of any third party. That was their basic plea. And defendant number 2 admitted that he has engaged this third party plaintiff by virtue of the power of attorney and another agreement. And he has executed all the works. Work was not under dispute. Now court, after hearing the parties, decided that no, there was no cause of action arose against the defendant number 1, who is the original contractor, as he is not the signatory of the power of attorney holder, neither in agreement, so there is no cause of action against the defendant number 1. And on that very ground, the suit was dismissed for want of cause of action. This is the brief of the case, Lordship. Suit was dismissed for want of cause of action, Lordship. Now, Lordship, kindly came to...
Let us come to your suit first.
Yes, Lordship. Page 15. Page 15 to 14:7. A suit for recovery of rupees 2 crores 38 lakhs along with the interest of 12% from the date of due till actual realization of full amount from the defendant
Recovery.
number 1.
Why recovery?
Because he is the third party, Your Honor, who executed the work, and the actual
Okay.
contract in favor of
The plaintiffs are the third party
third party
who executed the work.
executed.
What
the
kind of work was that?
work was that, Lordship, for construction of building, school building, amounting rupees to 4 crores 88 lakhs 51,514.50, and boys hostel cum kitchen building amounting rupees 3 crores 46 lakhs 39,220 under Ecologbo Model Residential School, Julwa, Mizoram, was issued in his favor by Government of Mizoram in favor of respondent number 1. Then respondent number 1 issued the power of attorney in favor of the defendant number 2 for execution of the work.
How many buildings? 2 buildings.
Two buildings.
One is school building and one is boys hostel.
Yes.
Okay. Then you have executed
Power
which
of
one?
attorney, Lordship. Power of attorney, Lordship, will find as page 27, Lordship. Page 27. Merit, Lordship. Point number 1, in favor of M. Chakru, who is the defendant number 2, that my attorney is authorized to perform and execute the work of construction, including cost of index labors as of a school building amounting rupees such and such, and a building boys hostel cum kitchen building amounting rupees 3 crores such and such under Ecologbo Model Residential School. Point number 2, very short, Your Honor. that my attorney is also authorized to do all other necessary acts and things in regards to the aforesaid work on my behalf, which shall be binding on me in full force or effect. Number 3, that my power of attorney will not be dissolved, irrevocable, even if I expired, that my power of attorney is irrevocable by both the parties. That is the power of attorney executed in favor of defendant number 2 by defendant number 1. Now, Lordship came to the page 26, Lordship.
No, defendant number 1 has executed
Yes.
power of attorney in favor of defendant number 2.
Defendant number 2. Now, defendant number 2 executed another power of attorney, Lordship, page 26.
Just a minute.
Point number 1, Lordship, that I was appointed as a true and legal attorney.
Just a minute. Just
Yes.
a minute. Which page number you say?
Page 26, Lordship.
26.
26.
Before that, you showed me 27, isn't it? You have shown me 27 first.
Yes, 27 first. Because this was
Now you're taking me back to 26.
26.
Yes.
26 issued power of attorney between respondent number 2, defendant number 2, and the present plaintiff, appellant, Lordship.
Defendant number 2
2
and plaintiff.
and plaintiff, appellant.
Plaintiff number 1 is father.
Lordship.
Plaintiff number 1,
Oh, plaintiff number 1 is the Lordship.
father.
There is no
Father of plaintiff number 2.
no Lordship. Actually,
Somebody
this-
expired.
Yes, this Gyasuddin, your Lordship will find as page 27.
No, Mohammed Jainal Ahmed.
Yes.
He expired.
No, he is alive, Lordship. The Gyasuddin expired and his wife was impleaded, Lordship.
Gyasuddin.
Yes.
Number 2.
Gyasuddin Mira.
Plaintiff number 2 expired.
Yes. Represented by his wife, Srimati Kayatun Nisa Mira. And on the later part, by virtue of agreement, Lordship, the plaintiff number 1 added in this execution of the
No, just a minute. First of all, this construction contract was given to whom? In whose favor? Of number 1.
number 1.
Number 1 gave power of attorney to number 2.
Number 2.
Then defendant number 2 again gave
Give to plaintiff.
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 Both the plaintiffs. There are
Power
two
of
plaintiffs.
attorney given in favor of only this plaintiff number 2.
Then why 1 is there?
Yes, one is there because Lordship thereafter on expire, when this plaintiff number 2 expired, then another agreement was executed between this defendant number 2 and this Muhammad Jainal Ahmed and Gyasuddin. Before expire, sorry, before expire.
Between whom? Plaintiff number
It's-
1 and 2 and
Plaintiff 1 and 2 and the defendant number 2.
okay.
It's
So
page
no-
28.
Oh, okay. Now you want to show me 26 first.
Yes, Lordship.
26. This is between
2 and plaintiff, Lordship.
plaintiff number 2
Plaintiff number 2.
and defendant number 2.
Defendant number 2.
Okay. Thereafter?
Yes, I was appointed as a true and legal attorney of Banlan Lifia Raute, chairman of NECS, to perform and execute the construction work of including such and such work. Number 2, that I authorize my attorney to perform and execute the aforesaid construction work. that my attorney is authorized to receive all the bills which shall be deposited in his State Bank of India account number such and such, that my attorney is also authorized to all other necessary acts and things in regards to the aforementioned work on my behalf which shall be binding on me in full force or effect, that my power of attorney will not be dissolved irrevocable even if I expect that my power of attorney is irrevocable by both sides, that I am ready to ratify all what my attorney does in action with his power of attorney. This is between the defendant number 2 and the plaintiff, Lordship.
Number 2, then plaintiff.
Yes.
Then one more.
Yeah. Now, Lordship, kindly turn to page 28. This is the agreement
Between?
between the defendant number 2 and these two plaintiffs. By this agreement, plaintiff number 1 aided in execution of this work, Lordship.
Work comprises of both the work, school and hostel also.
Yes. Accordingly, Lordship,
Amount is only 3 crores. Your claim for your suit?
suit for
2 crores.
2 crores 38 lakhs, Lordship.
Who executed the other work?
Lordship, after so far my information about 80% work was executed by the these plaintiffs, and then suddenly defendant number 1 stopped their construction, saying that I have no agreement with you. You stop the work. From our own side, we will proceed further work. And accordingly, they stopped. Then, Lordship, he claimed his amount up to whatever due amount on that particular period, Lordship, up to 80% or 75%. That was the claim.
Okay.
And failing to payment, this suit was instituted against the respondent number 1 and others.
Please read the agreement, page 28.
Yes. Whereas the first party nominate, constitute, appoint the second party to his lawful attorney to perform and execute the construction work of rupees such and such and boys hostel come kitchen building amount such and such. And whereas the second party and the third party agreed work together for the aforesaid construction work, and whereas the second party and the third party agreed to pay 15% of the total amount to estimated rupees 1 crore 25 lakhs 23,610 for the aforesaid construction to the first party in installment, and whereas the second party and the third party agreed to pay 3 lakhs to
30 lakhs.
30 lakhs to the third party at the start of the construction work, and whereas all the parties agreed that the second party and the third party shall pay the remaining balance of rupees 95 lakhs 23,610 to the first party in 3 installment. Now this deed of agreement witness that as from today the second party and the third party shall perform and execute the construction work including the cost of such and such, both the two works, Lordship.
Second party means the plaintiffs.
Plaintiff number 1.
Okay, then?
Then they started their construction work and they continued till February 2023. On February 2023, Lordship, particularly on 2/2/2023, they were stopped from the work and they were forced to withdraw the construction, their men and material from the construction site. Then
At what point of time the work stopped?
on February 2023.
Page 32.
Page 32, Lordship.
Expenditure is given on top.
Yes,
2nd February 2023. Up till this time,
yes, Lordship.
from 5/3/21,
Yes, Lordship.
amount is 3 crores.
Yes, Lordship. And they received, Lordship, 1 crore 20 lakhs.
So minus this amount,
Yes, minus this amount, remaining is
balance is 2 crores 38 lakhs,
38 lakhs.
6,000.
Yes, Lordship. That
So-
was their claim, Lordship.
The one, the Chaku, number 2.
Yes, Lordship.
Defendant number 2 gave the plaintiffs 1 crore 20 lakhs.
20 lakhs, Lordship.
Okay.
And against the non-payment of this claim amount, Lordship, the civil suit was instituted.
Okay. Any notice?
Upon the respondent?
Yes.
Yes, Lordship, notice has been issued.
No. Before making the claim.
Yes, Lordship.
Any legal notice you served?
Legal notice has been served, Lordship.
Where is that? Page 39.
Yes, Lordship. Page 42 also, one of the, page 39, Lordship. Page 39.
2 crores 61. Okay. But the amount is a bit different.
Lordship.
You are claiming in the notice payment of 2 crores 61 lakhs.
Cost of notice was added, Lordship, 15,000.
No, cost of notice is 15,000 only. You are adding interest also, that's why.
Yes.
But how much is your claim?
In the suit, Lordship, our claim is 2 crore 38 lakhs with 12% interest, Lordship.
Then after this notice, nothing happened? Then you file civil suit?
Yes. In civil suit, all the respondent appeared and submitted their WS, Lordship. Written statement.
Yes, what does it
Yes.
say? WS?
WS defendant number 1 filed on 11, annexure 3, Lordship, page 52. Onwards.
52
Yes.
by D1.
53 onwards is the material part, Lordship.
D1 had agreement with D2.
Yes.
D2 had agreement with the plaintiffs.
Plaintiffs. Basically, in the WS, Lordship, they have taken the plea that they have not authorized, or there was no specific clause in the power of attorney which was issued in favor of the defendant number 2 that he can subdelegate his power for execution of this work.
So that is the crux of the matter.
Yes. And learned trial court, but the defendant number 2 also filed WS, Lordship. Is annexure 4, page 62 to 73.
Just a minute. Sir.
He appeared and stated in the WS that yes, I am authorized and I engaged through this power of attorney and by agreement to execute the contract work, and the plaintiff accordingly executed and his claim amount is correct. He is eligible to get this amount, and the defendant number 1 has knowledge with consent with the consent of defendant number 1, I issued this power of attorney in favor of the plaintiffs, and they are entitled for the claim amount.
Where's the WS of DW2, D2?
Yes, Lordship. Page 62. Lordship.
62.
Page 62 onwards.
Where is the admission that
Lordship, page 67, paragraph 5.
read from where?
Yes. Paragraph 5, Lordship, page 67, that from the facts and circumstances of the case, the defendant number 2 would like to state and submits that he has been authorized to execute the aforesaid contract work by executing power of attorney dated 12/1/2021 by the defendant number 1. It may be specifically mentioned that the said power of attorney dated 12/1/2021 not only it contains specific clause for restriction, but specific clause for restriction of subdelegation to the third party or any person. In fact, the defendant number 2 was authorized to do all other necessary acts and things in regards to the aforesaid work on behalf of the defendant number 1. The same would bind on the defendant number 1 in full force and effect. Therefore, appointing the plaintiff to supervise and to execute the said contract work was well within the power and authority that was afforded to the defendant number 2, and the same cannot be objected by the defendant number 1 in any manner. Further, such action of the defendant number 2 was well acknowledged by the defendant number 1, as can be appreciated from the payment made by him. If at all the action of the defendant number 2 was not appreciated by defendant number 1, the same would have been communicated to the defendant number 2 when the construction works begin, since the defendant number 1 representative had also occasionally visited the construction site. That with regards to the para 9 of the written statement submitted by the defendant number 1, the defendant number 2 would like to state and submit that since there was no specific clause for restriction of subdelegation to the third party or any person, and that the defendant number 2 being fully authorized to do all other necessary acts and things in regards to the aforesaid work, it is unnecessary for the defendant number 1 to be part of the party of the signatory in the power of attorney executed between the defendant number 2 and the plaintiff, as already stated the preceding paragraph. Defendant number 2 appointing the plaintiff to supervise and to execute the said contract work as well within his power and authority that was afforded to him, and same necessarily need not be informed to the defendant number 1, binds the defendant binds that purported deed of revocation of power of attorney dated such and such, the defendant number 1 written statement was strongly objected, and the defendant number 1 be put to strict proof of the same, and same was never communicated to the defendant number 2 till date. In fact, the defendant number 1 also stated in para 3 of his power of attorney dated such and such that his power of attorney executed by him will not be dissolved or irrevocable even if he expire. Next, I am coming to the last part, Lordship. Paragraph, page 69, para 7, Lordship. The defendant number 2 would like to state and submits that in any event, since he was authorized by the defendant number 1 by power of attorney to all necessary acts and things in regards to the aforesaid work on behalf of the defendant number 1, rightly or wrongly, the defendant number 2 and the plaintiff had done the said construction work and completed most of the structural works, and with regards to all the alleged deed of revocation of power of attorney dated 17/6/2023, not admitting the same but the argument sake, the defendant number 2 would like to state and submits that the deed of revocation of power of attorney was only deemed to have been executed dated on 17/6/2023, meaning thereby the said deed of revocation of power of attorney could not come into effect from 17/6/2023. In such event, the power of attorney executed by the defendant number 1 dated 12/1/2021 could be deemed inoperative and effective till 16/6/2023. Therefore, whatever the amount bill payable for the said construction work up to 17/6/2023 is clearly liable to be paid by the defendant number 1, and in fact, any bill sanctioned by the Department of Social Welfare and Tribal Affairs, Government of Mizoram, that is the construction of building, cost index and labor cess, school building amounting rupees such and such under a Colombo residential school should be paid to the defendant number 2. In other words, all the cost amount incurred for the construction of the said contract work up to 17/6/2023 are liable to be paid by the defendant number 1 to the plaintiff through the defendant number 2. This is the clear admission, Lordship. And even in the statement of the defendant number 1, the work is not under dispute. They only disputed the authority of the defendant number 2 in execution of the power of attorney, subsequent power of attorney.
Then what else?
Yes. Then, Lordship, the suit was dismissed by.
No, 3 and 4, who are they?
They are the government, Lordship.
Oh.
They also submitted their.
What do they say?
Just a second. Page 74, Lordship.
They are, in fact, saying that the work order was issued in favor of the NECS.
They are only confined to the work order.
We are not concerned with the others.
Yes,
That's all.
that's all.
And what is page 77, agreement?
Pardon?
Page 77.
Page 77, Lordship. It's a contract agreement between the government and the NEC, Lordship.
Okay. So after WS, then what happened?
Then impugn order has been passed, Lordship.
Some hearing was done on maintainability,
On maintainability.
pre-hearing,
Yes,
maintainability.
yes. Order 7 rule L.
Yes, let's see the order.
Yes. This suit filed by the Muhammad Jainal Abedin and Ghosh Uddin Mira against defendant number 1 paying such and such amount had both sides on maintainability. The counsel for the plaintiff submits that plaintiff has locus standi as they had suffered injury. The case was filed within time and not barred by law of limitation. There is also cause of action against the defendants and there is no infirmity in the plaint to reject the plaint. The counsel thereby prays to court to maintain the case. On the other hand, the counsel for the defendant number 1 argued and submitted that the plaintiff has no cause of action against the defendant number 1 as the power of attorney dated 12/1/2021 was signed between the defendant number 1 and defendant number 2. The power of attorney dated 5/2/2021 and the agreement dated 5/2/2021 were signed between the defendant number 2 and the plaintiff. Hence, the defendant number 1 is not the party in the power of attorney and agreement. The counsel for the defendant number 1 relied in the decision of the Honorable Supreme Court the case of Mita India Private Limited and Mohendra Jain 2023 SC Online, wherein it was held that the law is settled that though the general power of attorney holder cannot delegate his power to another person, but same can be delegate when there is a specific clause permitting subdelegation. The counsel further submitted that there is no clause permitting subdelegation in the power of attorney dated 12/1/2021 signed between the defendant number 1 and the defendant number 2. In case of Devan versus Arvindbhai Koilanji, reported in 2020 SC Online, the Honorable Supreme Court held that the court must examine the plaint and determine when the right to sue first accrued to the plaintiff and whether the assumed fact the plaintiff is within time. The words right to sue means the right to seek relief by means of legal proceeding. The right to sue accrues only when the cause of action arises. The suit must be instituted when the right asserted in the suit infringed or when there is a clear or unequivocal threat to the infringe such right by the defendant against whom the suit is instituted. The plaintiff's claim against defendant number 1 hinges on the validity of the agreement executed on 12 January 2021 and February 5, 2021. The core issue is whether defendant number 2, acting under a power of attorney granted by defendant number 1, had the authority to subdelegate that power to the plaintiff. The court find that the power of attorney dated 12 January 2021 lack an explicit clause permitting subdelegation. The absence of express authorization is crucial. Absent express permission, an agent cannot delegate their authority to a third party, the plaintiff in this case. Therefore, the defendant number 2's subsequent power of attorney dated 5 February 2021 and the agreement executed on the same date with the plaintiff are considered unauthorized acts. The plaintiff's argument that the cause of action arose on 12 January 2021, the date of the initial power of attorney, is insufficient. While the initial power of attorney established the agency relationship between defendant number 1 and defendant number 2, the plaintiff claim is predicated on the subsequent action of the defendant number 2, specifically the subdelegation of the authority and the resulting agreement. These actions being unauthorized cannot binding on defendant number 1. The plaintiff's claim against defendant number 1 is therefore based on invalid subdelegation of authority. The court finding the plaintiff failed to disclose a cause of action against defendant number 1 stem from this fundamental flaw. The plaintiff right to claim against defendant number 1 is contingent upon the validity of subdelegation, which the court has deemed invalid due to lack of express authorization in the initial power of attorney. The plaintiff reliance on the 5th February 2021 agreement is misplaced, as this agreement are voidable due to defendant number 2's lack authority to act on behalf of the defendant number 1 in that capacity. Consequently, the plaintiff has not established a legally cognizable claim against defendant number 1. The plaintiff cause of action, if any, lies solely against defendant number 2 for exceeding their authority. Hence, the court is of the opinion that plaintiff did not disclose a cause of action against defendant number 1. In the Ivan case, the Honorable Apex Court decided that provision of Order 7 Rule 11 is mandatory in nature. It stated that the plaint shall be rejected if any of the grounds specified in clause A to E are made out. If the court finds that the plaint does not disclose a cause of action or that the suit barred by any law, the court has no option but to reject the plaint. In view of the above, the plaint is rejected. Order 7 Rule 11. Now, Lordship, first of all, in premature stage, the court has dismissed the suit for want of cause of action. There is, even Lordship, coming on later part, there was sufficient cause of action, and that particular aspect which was highlighted in this case, Lordship, that authorization, it is one of the aspect, one of the ground. The whole plaint cannot be rejected on the basis of one issue, Lordship. There is multiple facts which required evidence at the stage of evidentiary stage during trial, Lordship. And even the judgment which has been quoted in the impugn order, Lordship, for cause of action, that judgment itself says that this power under Order 7 Rule 11 should be used by the learned trial court very sparingly in exceptional cases. Here in this case, Lordship, first of all, the agreement between the
No, what is that?
defendant
Power under?
Order 7 Rule 11.
Order 7, Rule 8.
Rule 11, Lordship.
Rule 11. Rejection of plaint.
Rejection of plaint. Court has the power. There is no doubt, Lordship. But this power very exceptionally used only where there is prima facie no cause of action. In this case, Lordship, there is multiple issues involved. There is sufficient cause of action. Mainly, Lordship, the agreement was executed between the defendant number 1 and 2, admitted. The work was admitted. It has been proved on the statement of both the defendant number 1 and defendant number 2 written statement. This fact has been cleared that the work has been executed by the plaintiffs and a substantial amount has been they invested in this work, Lordship. And suddenly, after completion of substantial amount of work at the stage of final stage, when they about to get the fruits, only then it was rejected, stopped by the defendant number 1. And even if, for the sake of argument, we believe that that act of the defendant number 2 was unauthorized, why not it is stopped at the beginning stage? That means the defendant number 1 has the knowledge of the execution of the work, that this particular work is executing by the plaintiffs. And he wait up to the 18%, 80% of the work. And he get all the benefit. The work order in his name, the work is allotted in his name, the bill has been raised in his name, everything in his name. That means he has the knowledge.
Work order was in favor of defendant number 1. Defendant number 1.
Yes, Lordship. There is an agreement, Lordship.
Work
And
was allotted to somebody else.
Defendant
Oh, one
number-
only, okay.
Yes, defendant number 1.
Oh, correct.
He has the knowledge. Even this part, we forget that the authorization even illegal. That part he overtakes, respondent number 2. Even then, section 227 of the Contract Act protected the plaintiffs. May I read, Lordship? 227 of the contract. Because these things has been proved crystal clear that defendant number 1 has the knowledge.
Contract Act. Which section?
237. Other section also protected. I am just specifically 237 I am reading, Lordship. Liability of principal, including belief that agent unauthorized act or authorized. When an agent has, without authority, done acts or incurred obligation to third person on behalf of his principal, the principal is bound by such acts and obligation if he has by his word or conduct induced such third person to believe that such act and obligations are within the scope of his agent authority. Here in this case, Lordship, in 2021, the authorization has been given to the plaintiffs and he has been working continuously. And the defendant number 1 has the knowledge. That means his conduct, here conduct will apply, Lordship. His conduct is sufficient for the plaintiff to believe that his attorneys, all the acts are legal. I am just sake of argument just pressing this section, Lordship. Otherwise, there is other lots of cause of action which required to be proved. Even the knowledge, everything required to prove at the stage of evidence by adducing evidences. So the learned trial court failed to just use the judicious mind in this case while dismissing the plaintiff for want of cause of action against the defendant number 1. Because there are sufficient evidence against the defendant number 1 that the cause of action arose against the defendant number 1 and he has the liability. And if he has anything to say, he can prove it during trial. So in the very immature stage, the suit cannot be rejected as a whole. So my humble submission is that, Lordship, at this stage, the matter may be decided on merit. this civil suit may be restored by remanding back to the Learned Trial Court.
Any authority?
Lordship,
Any citation?
Lordship. First of all, I am reading the one judgment which is quoted in the order itself regarding the power of attorney, Lordship. Mita India, Lordship. Because in that very judgment, the Supreme Court clarifies the contention of use.
Have you given the list of books?
No, Lordship. The paper book has not been prepared in this.
So you'll read and I'll hear. Is it sufficient? You have to supply.
Yes, yes, Lordship. I have the-
You have a spare copy?
Yes.
Spare.
Operative part I highlighted, Lordship. In this case. Para 13, Lordship. I would like to read.
No, let us understand the judgment as it
Yes.
is. What is this? Mita India.
Yes, Lordship. Regarding the authorized.
Was it referred?
Yes, in
I was
the
referred.
impugn order, Lordship. Page 90, Lordship. The guideline was framed whether the power of attorney, how the power of attorney was accepted.
Cannot delegate his power to another person, but the same can be delegated where there is specific clause permitting sub-delegation.
Yes.
But is there any such provision for sub-delegation?
Yes, there is a clause, Lordship, but not specific. They disputed this aspect. That
Which
there is-
one? Which one? Show
the-
me
yes.
just now.
Page 28, Lordship.
28.
27, Lordship, sorry.
Yes, which one?
Point number 2, that my attorney is also authorized to do all other necessary acts and things in regards to the aforesaid work on my behalf, which shall be binding on me in full force or effect. All other works and things. In that reference, I would like to read this paragraph 13 and 14, Lordship, of this judgment. The quoted judgment itself.
You want to read in the subletting in this provision?
Yes, Lordship.
In paragraph 2. Paragraph 2 of the power of attorney.
Yes, Lordship.
You want to say that the power to sublet also should be read into it?
Yes.
Okay.
Based
So let
on
us-
contention of the based on contention of the power of attorney, and that it's this judgment itself explains these things, Lordship. I'll take 2 minutes, Lordship. Page start.
No, we'll read from the beginning.
Okay.
We have to understand this case.
Yes. Heard, Mr. Sergeant Learned Counsel. Paragraph 2, Lordship. Under the challenge, the judgment and order dated 4/4/2019 passed by the learned single judge of the High Court in exercise of power under Section 482 CRPC, setting aside the order of the trial court dated such and such and that of the divisional court dated such and such. Lordship, I am skipping the paragraph 3. In my copy, it's not legible, Lordship. The paragraph 4. The appellant company, through its unauthorized representative, Rapanjit Singh Kohli, filed a complaint in the Court of Chief Judicial Magistrate Dewas under Section 138, read with Section 141, 142 of the Negotiable Instrument Act 1881. In the said complaint, the respondent moved two applications. First, alleging that the complaint has not been fixed filed by an authorized person, and the second alleging that such and such cannot depose on behalf of the court as the complainant. In my court, it's difficult. Having knowledge about the facts of the case. Now it's clear. Page second page, paragraph 5. The first application was rejected by the trial court by order dated 31/2018. The second application was rejected on 23/7/2018, whereupon the criminal revision was filed, which was dismissed by order dated such and such. These three orders were assailed by the respondent by invoking jurisdiction under 482 CRPC. The High Court, by the impugn order, has allowed the petition filed under section 482 CRPC and has ordered for setting aside the above orders on the ground that the complaint was not filed by a person authorized, as Kavindra Singh Anand, who was given the power of attorney, had no authority of law to subdelegate the said power to the authorized representative Rapanjit Singh Kohli. Secondly, on the ground that Kavindra Singh Anand is not authorized to depose on behalf of the company. In support, reliance has been placed upon the decision of this court in Narayana versus State of Maharashtra. The apex court, through the above decision, has laid down the following principle. Sixth principle was laid down, Lordship, and principle number 4. Function under general power of attorney cannot be delegated to another person without a specific clause permitting the same in the general power of attorney. Now coming to the para 8, Lordship. It is in the light of the above dictum, the law laid down by this court, the above case, it is to be examined that the complainant has filed is maintainable and the High Court is justified in exercise of its power under section 482 CRPC to set aside the order of the trial court and that of the revisional court, holding that the complaint is maintainable as it has been filed by the authorized representative, power of attorney holder, and that the said power of attorney holder is legally entitled to depose in support of the complaint. A bare perusal of the complaint filed by the appellant company reveals that it has been filed in the name of the company, though it is authorized representative Rapanjit Singh Kohli. Therefore, the complaint is by the appellant company in its own name. It has not been filed in the name of the power of attorney holder. The complainant that in the appellant company is entitled to file the complaint in its own name through its power of attorney holder. There is a general power of attorney of the appellant company in favor of one of its director, Kavindra Singh Anand. The said power of attorney was executed after it was duly approved by the board of directors in its meeting dated such and such. Therefore, one of the director of the appellant company, that is Kavindra Singh Anand, is holding the power of attorney of the appellant company and is of the true and lawful power of attorney of the same. The said power of attorney explicitly authorized him to appoint counsel or special attorneys or conducting all cases or otherwise to do all other acts and things or due prosecution and defense of legal and quasi-legal proceeding anywhere in the world. The aforesaid power of attorney Kavindra Singh Anand, on the strength of the aforesaid power of attorney, authorized Rapanjit Singh Kohli to lodge the aforesaid complaint. The law is settled that though the general power of attorney holder cannot delegate his power to the another person, but same can be delegated when there is a specific clause permitting subdelegation. A careful reading of the general power of attorney would reveal that the appellant company in its meeting of the board of directors held 1st May 2010 has resolved to appoint one of the director, Kavindra Singh Anand, as its attorney of the company, who was specifically authorized by paragraph 2 to appoint counsel or special attorneys. The language deployed, that is to appoint special attorneys, is clear enough to indicate that power of attorney holder has been authorized to appoint special attorney in addition to the counsel conducting cases and doing other relevant and material acts in this connection. The use of words to appoint counsel or special attorneys would not mean that he was authorized only to appoint counsel or special counsel for the purpose. The use of the words counsel or special attorneys have different connotations. The use of the aforesaid words to appoint counsel for special attorney, paragraph 2 of the power of attorney, is quite distinct and refer to not only to appoint the counsel but also special attorneys other than the counsel. This is implicit upon the reading of the paragraph 16 of the power of attorney, which specifically deals with the appointment of the solicitor, counsel, advocates, other consultants and professionals, but does not refer to the attorneys. Therefore, a combined reading of the paragraph 2 and paragraph 16 of the power of attorney would bring home the fact that the power of attorney holder was authorized to appoint special attorney other than the counsel for the purposes of the conducting and prosecution of the cases on
Mr.
behalf of
Counsel, I think idea behind here is that there is a specific clause permitting sub-delegation. If there is one such like that, so it can be delegated. If
Yes.
there is a specific clause. In this case, court says that careful reading of the Board of Directors meeting held on so and so. There was a resolution that one so and so, Singh Anand, as its attorney, he was specifically authorized by paragraph number 2 to appoint counsel or special powers of attorney.
yes,
That thing was there, so court said that it can be done.
yes, but
In
there-
your case, where is it?
Lordship, there was authorization is given for the execution of work, and in this case also court considered the contention of use. Further point.
No, execution of work means what? That doesn't mean that you go and appoint somebody else.
All other acts necessary which to execute, and this execution of the second power of attorney is for the benefit of the defendant number 1 for the execution of the work itself, Lordship.
For benefit or not, we don't know. The thing is, we are only concerned with whether you are authorized to be appointed as, whether number 1 has authorized number 2 to appoint somebody else.
No, there was no such specific clause,
Then,
and court taken that plea. That is one of the aspect, and even then we, for the sake of agreement, admit that this authorization is unauthorized. This power of attorney. Then even the 227 of the Contract Act applied against the defendant number 1, because he has the knowledge, he get the benefit, his conduct.
what is the principles governing this 220, what do you call this?
237.
237?
If somebody has the knowledge and his conduct, let's say I'm reading again.
Knowledge is sufficient.
Knowledge and conduct is sufficient, Lordship, to make it bound. Implied ratification, Lordship. Liability of the principal inducing belief that agent unauthorized actor are authorized. And here in this case, it's clear, Lordship. Because work is admitted, bill has been raised, everything done. Just suddenly at the end of the work, saying that no, you are not authorized to proceed with the work, we will conclude our work from ourselves. And the attorney exceeded his limit.
No, who has stopped the work?
Defendant number 1.
Number
Lordship.
1 has stopped.
Yes.
So that means he has the knowledge.
He has the knowledge.
Otherwise, they would not have stopped you. You would have completed everything.
Yes. He could have stopped at the beginning while I am raising bill and everything, submitting bill in the
Yes.
office.
Anything else besides that?
And I am on 227 I am in line with your agenda. In a similar case, Lordship. Dispute regarding the supply of parcel, Lordship, courier, Lordship. I would like to read operative part, Lordship.
Before that, what is the subject?
Subject, Lordship, it's a consumer under the complaint was filed under consumer protection, Lordship. Regarding supply of some clothes by the flight cargo, Lordship. Same third party, Lordship. And bill was not issued against the defendant number, here in this case also defendant number 1, who denied that no, nothing in between me and the plaintiff.
You first of all read paragraph 1, 2.
Yes, Lordship. Challenge in appeal under section 23 of the Consumer Protection Act in 1986. is to the order dated 15 April 2002 passed by the National Consumer Dispute Redressal Commission in short session in original petition number 156/1995. The impugn order and the commission has dismissed appellant complaint alleging deficiency in service on the part of the Alitalia Cargo, respondent number 1, in this appeal on the ground that there was no privity of contract between the appellant and the respondent number 1. Respondent number 2 and 3 in this appeal, Ms. MS Omni Mark Travel Private Limited and General Sales Agent MS Fourways Movers Private Limited, Cargo Clearing Agent of the respondent number 1 respectively. They are the agent. The salient features giving rise to the present appeal are as follows. The appellant is engaging in business of export of ready-made garments and handicraft. They obtain an order from the MSDT sales concern based on Newark, USA for supply of 2025 pairs of cotton gents dhutis, 150 sets of cotton ladies gagra choli, 150 piece of dupatta, etc. As per the agreement between the appellant and the said concern of Newark, USA, these articles had to reach Newark, USA before 10th of October 1994. Accordingly, the appellant handed over the consignment to the said articles to the respondent number 3, MS Fourways Movers Private Limited, on 4th October 1994 for award dispersed to the Newark, for which a house airway bill number such and such was prepared by the respondent number 3 for the sake of ready reference, and the said bill is reproduced hereunder.
Bill you can skip.
Yes, Lord.
Then number 5.
Yes.
Last
On
five.
6th October 1994, a crafting order was appeared by the Alitalia Airlines handing over the consignment to the AAI Cargo Terminal in NITC, the IGA Airport, New Delhi, for shipment of flight AZ1905, a craft order board of endorsement, cargo accepted, subject to space. The parties are ad idem that the said house airway bill, as also the master airway bill, were issued under the seal and signature of MS Fourways Private Limited, respondent number 3. It is permitted to note that this juncture itself, that house airway bill number such and such had the master airway bill number such and such is running bill number printed on Alitalia printed bill book. Similarly, the house airway bill number 0841 was recorded on master airway bill. Since the consignment did not reach Newark by the stipulated date, MSDT Sales and Importer cancelled the order around 6th October 1994 and claimed damage for the appellants. The consignment reached to the destination only on 20 October 1994. Alleging deficiency in service on the part of the respondent, in particular by the respondent number 1, the appellant filed a complaint before the commission claiming 22.46 lakhs towards the value of the consignment, along with interest at the rate of 18% per annum thereon, and rupees 15 lakhs as special damage. The complaint was contested by the respondent number 1, repudiating the claim made by the appellant in the counter affidavit filed by the respondent number 1 while denying the negligence on their part resulting the deficiency in service. By way of preliminary objection, it was pleaded that there was no privity of contract between them and the appellant, and therefore the complaint was liable to be dismissed on the short ground. The stand of the respondent number 1 before the commission was that the airway bill such and such, which was issued by the respondent number 3 on behalf of the respondent number 1, did not mention the flight number and the date of column provided for the same. Since aircrafting of cargo was always subject to the load and space, it was reiterated the house airway bill such and such dated 4th October 1994 was neither issued by the respondent number 1 nor on its behalf. Both the party laid evidences before the commission by way of affidavit. Upon consideration of the evidence on record, commission dismissed the complaint aforestated ground, namely the appellant had no locus standi to file the complaint against the respondent number 1, while holding the commission observed thus. This is the judgment. The commission thus declined to go into the merit of the complaint, though it did not observe that there was lot that could be said on merit of appellant case. Being aggrieved the appellant claimant before this appeal, the Arvind Kumar Gupta learned counsel appearing on behalf of the appellant submitted that the commission submitted a serious error of law and the fact, dismissing the complaint on the sole ground that the appellant had failed to prove the privity of contact between them and the carrier, that is respondent number 1. According to the learned counsel, it's clear from the House Airway Bill as also Master Way Bill such and such that both the bills were prepared contemporaneously by respondent number 3 as respondent number 1, Carter's agent, when the consignment was handed over to them, and since the House Airway Bill recorded the appellant as the shipper and respondent number 3 as the issuing charter agent, the mention of the respondent number 3 as the shipper as well as an issuing charter agent in the Master Airway Bill is of no consequence. It was strenuously argued that from the said airway bills, it is clear that respondent number 3 was acting as an agent and respondent number 1, and therefore the said respondent as principal was bound by all the acts and omission and commission of his agent. It was asserted that commission failed to apply its mind on its aspects of the matter and therefore erred in holding that there was no privity of contact between the appellant and the respondent number 1. Sanjay Gupta learned counsel appearing on behalf of the respondent number 1 on the other hand supported the decision of the commission and submitted that since the master bill is the only contract of carrying between the consignor and the charter, and in the said bill the respondent number 3 having been named as shipper of DD Sales of New York as the consignee, respondent number 1 had no liability towards the appellant, notwithstanding the fact that the appellant had been named in the shipper in House Airway Bill 0841. It was submitted that since as per Part 3, Chapter 2 of the second schedule of the Carriage Airway Bill Act such and such, it is the consignor who is required to make out a airway bill and hand over the same to the carrier. It was the responsibility of the consignor to see that all the particulars and details of the cargo asserted in the airway bill are corrected. It was thus argued that respondent number 1 not being a party to the contract carriage vis-a-vis the appellant, the said respondent cannot be held liable for any delay and delivery of consignment in question. There is no quarrel with the proposition that as per section 4 of the Carriage Act, rules contained the second schedule govern the right and liabilities carrier, consignor, consignee, etc. Rules contained the second schedule apply to all the international carriage and persons, baggage and cargo performed by aircraft for reward. Chapter 2, the said schedule enumerates the documents of carriage. Rule 5 of the Part 3 of the said chapter stipulates that every carrier of cargo has the right to require the consignor to make out and hand over him to document called as airway bill. Very consignor has right to require to carrier to accept this document. Rule 6 provides that the airway bill shall be made out by the consignor in 3 original parts and be handed over with the cargo in the manner prescribed therein. Rule 10 makes its consignor responsible for the correctness of the particulars and the statement relating to the cargo which he inserted in the airway bill. As per Rule 11 of the airway bill, prima facie evidence of the conclusion of the contract. On receipt of the cargo, the conditions of carriage. In the light of this provision, we agree with the Commission that airway bill is prima facie evidence of the conclusion of the contract of the receipt of the cargo and condition of carriage. However, the question which, in our view, the Commission has failed to examine in this regards to the capacity in which respondent number 3 was operating and had collected the cargo from the appellant for being shipped to New York. In other words, what was the nature of relationship between the respondent number 3 and respondent number 1? Section 186 of the Contract Act lays down that authority of an agent may be expressed or implied. As per section 187 of the Contract Act, an authority is said to be expressed when it is given by words spoken or written, and an authority is said to be implied when it is to be inferred when circumstances of the case, and things spoken or written or ordinarily course of dealing which may be accounted circumstances of the case. Section 188 of the Contract Act prescribes that an agent having an authority to do an act has authority to every lawful things which is necessary in order to do such act. Section 237 of the Contract Act provides that when an agent has without authority done acts or incurred obligation to third person on behalf of his principal, the principal is bound by such acts or obligation if he has his words or conduct induce such third person to believe that such acts and obligation are within the scope of the agent authority. There is no gainsaying that on us to show that the act done by an agent was within the scope of his authority or ostensible authority held or exercised by him is on the person claiming against the principal. This of course can be shown by practice as well as by a written instrument. Thus, the question of consideration is whether on the evidence obtaining in the instant case can be said that respondent number 3 had an express or implied authority to act on behalf of the respondent number 1 as their agent. If respondent number 3 had such an authority, then obviously respondent number 1 was bound by commitment of respondent number 3 and made to the appellant. Having examined the question in the light of the aforestructured airway bill, which according to both the contesting parties and determinative the terms and condition contract between them, we have the opinion that respondent number 3 had an express authority to receive the cargo for and on behalf of the respondent number 1. This is manifest from the master airway bill number such and such issued and signed by respondent number 3 on the airway bill printed by the respondent number 1. But for the said authority, respondent number 3 could not use the airway bill pro forma printed by respondent number 1. Though it is true that the said airway bill, the name of the supplier has been mentioned as that respondent number 3, but said airway bill has also been signed by the respondent number 3 as the agent of the charter respondent number 1. The other relevant particulars like the name of the consignee and the number of the house airway bill 0841 etc. tally with the house airway bill issued by the respondent number 3 to the appellant clearly shows that name of the consignor as that of the appellant. From the said documents, it would appear that respondent number 3 was in fact acting in dual capacity, one as a supplier on behalf of the appellant and other as an agent of the respondent number 1. That brings so respondent number 1 was bound by the act of their agent, viz. Respondent number 3, with all its result. We are of the opinion that while holding that there was no privity of contract, the appellant and the respondent number 1, this vital aspect of the matter escaped the attention of the commission, thus besheet its order. In view of the aforesaid discussion, we know we have no option but to allow the appeal and set aside the impugn order. We order accordingly remit the matter back to the commission for fresh adjudication of the claim preferred by the appellant on its merit. However, in the fact of the circumstance of the case, there will be order of no cost. So here in this case also, Lordship, many facts remain untouched which required to prove during trial through evidence. Plaintiff and respondent also. So my humble prayer, Lordship, this matter may be remanded back to the learned trial court for a litigation on merits, Lordship.
No, how do you compare that case to this case? How do you compare?
Because this privity of contract in this case, Lordship, they have denied. And court established that there is an agreement and
You have read paragraph 13,
Lordship.
4th line. We are of the opinion. Just read that.
This manifest fourth line, paragraph 13, Lordship.
Yes, we are of your,
Having examined the question in the light of the two aforesaid exterior airway bill, which according to both the contesting parties are determinative in the terms and condition of the contract between them, we are of the opinion that respondent number 3 had an express authority to receive the cargo for on behalf of the respondent number 1.
then read again.
This
Continue.
is manifest from the master airway bill number such and such issued and signed by the respondent number 3 on the airway bill printed by the respondent number 1, but for the said authority respondent number 3 could not use the airway bill pro forma printed by the respondent number 1.
Yes, that much.
Yes.
The facts regarding is some garments being imported abroad, exported and imported that side. Did not reach in time, so they file a claim for compensation
Yes.
before the forum, this commission. And what they say is that the person who was supposed to supply that garment handed over the same to the shipper. That is respondent number 1. Respondent number 1 in turn gave it to respondent number 3.
Yes.
Correct. But there was a delay. Claim came, then respondent number 1 says that I'm not responsible. Respondent number 3 also says that he is not responsible. Ultimately, who was found to be responsible?
Respondent number 1.
Respondent number 1. So this is by reading section 237.
Yes.
237.
And another section also, I think, Lordship attracted
Which one?
of the Contract Act, section 70.
17.
70, Lordship.
70.
Yes.
Yes, what is it?
Obligation of person enjoying benefits of non-gratuitous act. Where a person lawfully does anything or for other person or delivers anything to him, not intending to do gratuitously, and such other person enjoy the benefits thereof, the latter is bound to make compensation to the former in respect of the restore of the things or so done or delivered. Here in this case, Lordship, dependent number 1 has get all the benefits. He received the benefits and the things done by the plaintiffs.
Payment was made to respondent number 1.
Yes.
And in turn, respondent number was supposed to pay to you.
Yes.
No, number 2.
1 and 2. Two saying no.
Agreement was between 1 and 2.
1 and 2.
And 2 has an agreement with you.
Yes.
1 says that I am nowhere concerned with this agreement.
Yes.
So court also agrees that there is no provision.
Court only take up specific one clause regarding this non-authorization or specific clause in the power of attorney. Court is silent all other aspects in its impugned order.
In other aspects means such as?
In other facts, like its knowledge and the section 237, 70, many things which will come on during trial.
So you are saying that court is solely on the point of there being no specific provision?
Yes, no specific provision, nothing else. When we are plain reading of the impugned order, there is, I don't find anything else.
Okay, that's your case then. We'll hear the other side.
Yes.
Yes, Mr. Papa.
May it please, Your Lordship. My Lord, at the outset, I'm for the respondent number 1, by the way. At the outset, what I would like to bring to the knowledge of this honorable court is that number 1, the case was not dismissed. it was rejected. The plaint was rejected under Order 7, Rule 11. So he has all the rights to reapproach the civil court again on the same provided he shows some kind of cause of action. Now, the reason why the plaint was rejected was because my learned friend before the learned trial court could not establish any cause of action against the defendant number 1 or respondent number 1. Now, the facts, Your Lordship, is very clear. I have delegated, I am a contractor. Contract was awarded to me. I've delegated my authority to the defendant number 2. My relationship of principal and agent is confined to respondent number 2 alone and no one else. Now, the defendant number 2, on their part, they have executed a separate agreement between themselves and the present appellant, into which I was not even a signatory, I was not even a witness, and I was unaware of it. Now, the first question is that I would like to bring to Your Lordship's consideration is whether I can be bound based on for the specific performance of a contract to which I was never a party. And number 2 is that my learned friend himself has read out certain judgments, and in no clear terms, as my learned friend has already admitted, that there is no specific sub-delegation clause in the power of attorney that I had executed between myself and the defendant, respondent number 2. That we have seen. So, under such circumstances, whether I should be made liable for payment of certain amount of money for specific performance of a contract which I am not a party to. Now, let us be clear. As far as I am concerned, my liability is towards the respondent number 2, and which I have satisfied. As per my last inquiry with my clients, my understanding is that whatever was due to be paid to the defendant number 2, the respondent number 2, I have already paid about 95%. Some 5% of the bill I'm yet to pay. Now, my learned friend has basically relied on Section 237 of the Contract Act and also Section 70. If we read Section 237 of the Contract Act closely and clearly, if we analyze it, I think the most important part is knowledge. The principal ought to have knowledge about the illegal act of the agent.
You said you had no knowledge.
I had no knowledge.
How do you say that?
I will come to their plaint, Your Lordship.
But the work was stopped, isn't it?
I stopped it after I came to knowledge. After I came to learn about the sub-delegation without my authority, I stopped the work. This is an admitted fact which they themselves have written in their plaint. Now, if I can take Your Lordship's attention to...
Just a minute, Court Master, he just called up. He called out Jamadar. Yes, which one?
Page 15, their plaint. The plaint submitted by the appellant.
15.
Now, one of the submissions of my learned friend was that I was aware of the delegation based on the bills that was raised.
Just a minute.
My lord.
निकाल दो अभी गर्म पानी लगा बीच बीच में चेंज करते रहना काफी टाइम हो गया नहीं आया Yes.
Now, his submission was that the appellant kept raising bills, and then that was always, to a certain extent, to a certain point of time, honored. So I was well aware of the fact that the work was being executed by the appellant. That was his submission. If I can take Your Lordship's attention to page 18, this is para 9 of the plaint of the appellant. May I read, Your Lordship? It says, the plaintiffs raised bills of each and every work performed for payment and receipt of such bills raised by the plaintiffs had been acknowledged by the defendant number 2, not 1, my lord. He had raised his bills to the defendant number 2, not me. So that is factually incorrect to say that I was aware of these bills being raised by the plaintiff appellant. And if we continue to read, Your Lordship, as already mentioned above, while the plaintiffs had undertakes their assigned work at their best, the plaintiffs had completed all the structural and the said construction work was in full force. To the utter surprise of the plaintiffs, they are forced to stop the contract work by the defendant number 1 without any proper justification on so and so 2/2/2023. Later on, the said construction work is taken up by the defendant number 1. Again, Your Lordship, out here, I would like to take Your Lordship's attention to the next paragraph, 10(1), at the next page, Your Lordship. That, with reference to the deed of agreement above mentioned in respect of the above mentioned contract work, the plaintiffs had pursued construction of the said work wherein the defendant number 1 through the defendant number 2, wherein the defendant number 1 through the defendant number 2 had informed the plaintiffs to stop their ongoing construction work midway in the month of December 2022. We told them to stop it in December 2022. This is their own admission. However, the plaintiffs had continued their construction till 2/2/2023 with all the parties' consent. This is a contradictory statement. So, from their own statement, from their own admission, it is clear that I was unaware of the situation. As soon as I came to know about it, I told them to stop, but they said nothing doing. We will continue to work for another 3 months. So, Your Lordship, the admitted fact is that, number 1, the respondent number 1 and the present appellant, we do not have any contractual relationship. We don't have any employer-employee relationship. We do not have any principal-agent relationship. Those are admitted fact. Now, if I can take Your Lordship's attention to page 22, this is the relief portion, prayer of the appellant. Para 20, sub-para 2. It says, let a decree be passed directing the defendant number 1 to make payment of the principal balance amount of so and so. When I don't have any contractual relationship with the appellant, how can there be any direction? What is his locus standi? My specific plea in my written statement in the beginning itself was that there is no cause of action. Number 2, there is no subdelegation in the contract, in the power of attorney executed between myself and the defendant respondent number 2. And thirdly, I do not have any contractual relationship with the appellant plaintiff. And yet he is praying for a decree for a specific direction against the respondent number 1 particularly and no one else. Had this prayer be a prayer for a direction to the defendants as a whole, then I would understand. But this is specific to the defendant number 1. So where is the question of a cause of action arising in favor of the appellant against the respondent number 1? And as I mentioned earlier, Your Lordship, this is a question of rejection of plaint. He can still file whatever civil suit on the same cause of action, provided there is one. In my humble opinion, if he has any grievance against any unpaid bills, it should be against the respondent number 2. Because as far as I'm concerned, I have paid all my whatever outstanding bills to the respondent number 2.
Yes.
Yes, Your Lordship. Coming back to the Indian Contract Act of 1872, Your Lordship, I would like to take Your Lordship's attention to Section 196. 196, 197, and 198.
Yes.
Section 196, right of person to acts done for him without his authority, effect of ratification. Where acts are done by one person on behalf of another, but without his knowledge or authority, he may elect to ratify or disown such act. If he ratifies them, the same effects will follow as if they had been performed by his authority. Now, 198 is key now, my lord. Knowledge requisite for valid ratification. No valid ratification can be made by a person whose knowledge of the facts of the case is materially defective. So from the beginning itself, from our written statement, we had always denied knowledge. And it is not the case of the appellant plaintiff that we had knowledge and in spite of that, we kept quiet. That is not their case. Now, coming back to section 237, Your Lordship, my learned friend had read out section 237. I would like to read 238.
Good.
Section 238 reads as such. Principle not bound when excess of agent's authority is not separable. Where an agent does more than he is authorized to do, and what he does beyond the scope of his authority cannot be separated from what is within it, the principal is not bound to recognize the transaction. So, in the power of attorney that I had executed in favor of the respondent number 2, there was no specific clause for subdelegation. So, the provision of section 227 cannot come to the rescue of the appellant, unfortunately, in this case. Now,
238, what does it mean?
in my humble opinion, if the agent acts beyond the authority that was given to the agent by the principal, that cannot bind the principal. In other words, illegal acts of the agent cannot bind the principal. I think the illustration may be handy, Your Lordship.
Yes.
So, Your Lordship, even putting aside the issue of cause of action, even yes, Your Lordship, even putting aside the question of the cause of action, by relying on the law of equity, whether this case can be deemed to be fair, especially in light of the fact that as far for one particular, for the same work, I have already made my payment to the respondent number 2. And now he's saying that I also have to pay him. How can I pay twice for the same work, for the same transaction? So let's assume that the power of attorney that was executed between them, although I'm not even assuming, I'm saying it's illegal. The plaintiff appellant still has a cause of action so far as the respondent number 2 is concerned, because they do have an agreement between them. And they have also acknowledged that certain amount of money had already been paid by the respondent number 2 to the appellant. So this is a dispute between them. It has nothing to do with me. If, let's say, the respondent number 2 has any issue in terms of whatever dues I may have against her, then that's a different issue. But how can the appellant, with whom I have no contractual relationship, how can I be made directly liable? That's why, in my humble opinion, the learned trial court was correct in rejecting the plaint as lacking cause of action. With that, I conclude my submission, Your Lordship. I have one citation, but since my learned friend had already read out that Mita India Limited, I think my learned friend has already covered it, so I will not bring it out again.
Lordship, I'm defendant number 2.
Yes.
And first, I would like to read the RFA number 9, Roman number 4, first para, the order,
RFA.
impugn order.
Which paragraph? Number 9. No.
Order. It's a
Page?
Roman number 4. Got it, Your Lordship?
Which one?
Front.
Impugn order.
Order of the trial court.
Impugn order.
Impugn order.
Yes. The paragraph, it's not numbered.
It's not numbered. The page 4, Roman number 4.
Yes.
Yeah, Your Lordship. Here, the citation is that Supreme Court on the case of Mita India Private Limited versus Mahendra Jain 2023 SCC Online SC 163, wherein it was held that the law is settled that though the general power of attorney holder cannot delegate his power to another person, but the same can be delegated when there is specific clause permitting subdelegation. So in this case, Your Lordship, in the power of attorney, there is no restriction with regard to the power, delegate power to another person. It's not restricted at all. So, Your Lordship, it's already seen that power of attorney, that is in page 27,
Hmm. 27.
yeah, paragraph number 2, that my attorney is also authorized to do all other necessary acts, things in regard to the aforesaid work on my behalf, which shall be binding on me. It's very clear. Which shall be binding on me in full force or effect. So, with regard to this, the defendant number 5, number 2 was authorized, is permitted or authorized to appoint plaintiff to supervise and to execute the state contract was well within the power of attorney. And beside this, if you read the power of attorney, Your Lordship, that my power of attorney will not be dissolved, irrevocable, even if I expire. That my power of attorney is irrevocable by both the parties. However, violating this power of the attorney, Your Lordship, the contract was stopped by the defendant number 1. So, Your Lordship, kindly see my written statement, paragraph number 5, that is in page 67.
Yes.
Here, I'll read, here it's, this point is very important, Your Lordship, that from the facts and circumstances of the case, the defendant number 2 would like to state and submit that he has been authorized to execute the aforesaid contract work by executing power of attorney dated such and such by the defendant number 1. It may be specifically mentioned that the state power of attorney dated 12/1/2021, not only it contains specific clause for restriction of sub-delegation to the third party or any person. In fact, the defendant number 2 was authorized to do all other necessary acts and things in regard to the aforesaid work on behalf of the defendant number 1, and the same would bind on the defendant number 1 in full force or effect. So, from this paragraph, there's a cause of action against defendant number 1. Therefore, appointing the plaintiff to supervise and to execute the said contract was well within the power and authority that was afforded to the defendant number 2, and the same cannot be objected by the defendant number 1 in any manner. Further, such action of the defendant number 2 was well knowledge by the defendant number 1, as can be appreciated from the payment made by him. If at all, the action of the defendant number 2 was not appreciated by the defendant number 1, the same would have been communicated to the defendant number 2 when the construction work began, since the defendant number 1 representative had also occasionally visited the construction site. I have made a statement that they have knowledge that I have appointed plaintiff to supervise and to execute the said contract work. So I have power to do so in accordance with the paragraph number 2 of the power of attorney. And I have support the appellant in other points, Lordship. So my contention is that cause of action against defendant number 1 is established by reading the power of attorney, paragraph number 2. So I am empowered to do any act and things. That is my submission, and even the defendant number 1 also visited the site, the construction site. Even his representative also visited. And besides this, Your Lordship, this power of attorney is irrevocable, but he had revoked the power of attorney and he stopped the work, and he is the one who violated the agreement, power of attorney.
This sentence at paragraph 60, page 67,
Yes,
the fourth last sentence,
yes,
page 67.
yes, I got it, Your Lordship.
Further, such action of the defendant number 2 was well acknowledged by the defendant number 1,
Yes.
as can be appreciated from the payment made by him. What is this payment?
Payment, the work already done by them, some, it's one lakh
1 crore 20 lakhs already paid.
already paid.
Payment paid by whom?
Paid by the defendant number 2 from defendant number
From, to me,
No, who paid who? Defendant number 1 paid?
paid to
plaintiff.
me, and I have paid all the,
They have not paid directly to him,
no,
through you.
to me. And
But,
I
but,
have.
but is the defendant number 1 aware about your payment to him?
Yes, because the construction work done by them also, I have informed. Even they visited the site by themselves or sometimes by their representative. I have statement, paragraph 5.
Okay.
So, the impugn order may be set aside and remanded the case to the lower court and trial the case. Take evidence and all, Your Lordship.
May I please, Lordship?
That's it?
Yes, that is.
I would like to add one thing, Lordship, regarding the jurisdiction of the Lionel Trial Court, regarding this rejection, Lordship. On what condition the plaint can be rejected? The Honorable Supreme Court in some judgment, I am relying for them, Lordship. One is voluminous was Liverpool and London SP Ioham Burch's MB Shina success, Lordship.
Regarding?
Regarding the Order 7 Rule 11.
What does it say? Do you have a copy of your own? Which paragraph?
Fourth page from last, Lordship.
Huh?
From last side, Lordship, fourth. Last fourth.
You should have paginated it. Yes.
May I read, Lordship?
Read from where?
In paragraph 4, Lordship.
It's not numbered. How does it start? No, why are you giving me that copy? Don't give me that copy. Is it not the same?
Same copy.
Then,
Just I am
is it numbered there?
not numbered,
Then-
Lordship, but starting point I find.
If it's not numbered, then what difference would it make? How do you begin the sentence?
In ascertaining whether the plaint show a cause of action, Lordship.
Yes, read.
Yes. The court is not required to make an elaborate inquiry into doubtful or complicated question of law or facts. By the statute, the jurisdiction of the court is restricted to ascertain whether on the allegation a cause of action is shown. In Vijay Pratap Singh Barchas Dukh Haran Nath Singh reported in such and such. By the express term of R5 clause D, the court is concerned to ascertain whether the allegation made in the petition show a cause of action. The court has not seen whether a claim made by the petitioner is likely to succeed. It has merely to satisfy itself that the allegation made in the petition, if the accepted as true, would entitle the petitioner to would be shown, and the petition the relief is he claimed. If accepted those allegations as true, no case is made out for grant relief and no cause of action would be shown. The petition must be rejected, but ascertaining whether the petition show a cause of action, the court does not enter upon a trial of the issue affecting the merit of the claim made by the petitioner. It cannot take into consideration the defense which the defendant may raise upon the merit, nor is the court competent to make an elaborate inquiry into the doubtful or complicated question of law or fact. If the allegation in the petition prima facie show a cause of action, the court cannot embark upon an inquiry whether the allegations are true in fact or whether the petitioner will succeed in the claim made by him.
I think you can stop right there. How is it applicable to your case? I don't find the
Yes,
applicability.
I am saying the case is, the plaint is rejected on a very premature stage.
No, I know. What you want to say is that at that stage, court cannot say that this plaint will succeed or it will not succeed.
Yes, there is,
So that determination is not required.
yes, prima facie there is cause of action.
So what the court is required to do, otherwise under Order 7 Rule 11 is to see whether the cause of action is there or not.
Yes,
So court had examined that.
yes.
Court did not say anywhere that it may not succeed, so I am not entertaining.
I am saying that, Lordship, the defense has.
So how will it be applicable to your case? And secondly, you did not quote which rule you are, which order, which section you are quoting here. This pertains to Admiralty Courts Act 1861.
No, it's related to Order 7 Rule 11.
You should mention that.
It's related to,
You read by express terms of R5, you said. R5 means what? Rule 5. Subclause D.
Ji.
This is of which provision? Admiralty Courts Act, I think, 1861. Anyway, you sit down.
Yes.
Let me pass the order. Art, Mr.
T.A. Chaudhary, Lordship.
T.A. Chaudhary, Learned Counsel for the appellant, comma, Mr. Lal Fakoma, Learned Counsel for the respondent number 1, comma, Mrs. Dinari T. Azu, Learned Counsel for respondent number 2. Anyone else?
Government is not present, Your Lordship.
Then you put and respondent number 2. Stop, no one appears for the respondent numbers 3 and 4. Next para. This is an appeal filed under section 96 of the Code of Civil Procedure 1809 bracket CPC. Read with Order 41 Rule 1 of the same code, CODE code. And also with section 17 bracket 2 bracket small b of the Mizoram Civil Courts Act, comma, 2005 against the impugn order dated 7/2/2025 passed by the Learned Civil Judge, Senior Division 1, Aizawl, in civil suit number 171 of 2023. Stop, by the impugn order, the Learned Court below dismissed the suit filed by the appellants on the ground that the plaintiff did not disclose a cause of action. Next para. Learned counsel for the appellant submits that the learned trial court by referring to Order 7, Rule 11, bracket small a, CPC, rejected the plaint for want of disclosure of cause of action. And while doing so, the learned trial court failed to take into consideration other aspects which is with regard to the knowledge of the respondent number 1 about the construction work being carried out by the appellants and also enjoying the benefit of the same. To stop referring to clause number 2 of the power of attorney entered between the respondent number 1 and respondent number 2 on 12/1/2021, the learned counsel submits that the respondent number 2 was duly authorized to do all necessary acts and things in regard to the construction work on behalf of the respondent number 1, and the same was accepted to be binding upon the respondent number 1 with full force or effect. To stop such being the position, the plaint submitted by the appellants could not have been rejected by the learned trial court. Stop in support of his submission, the learned counsel relies upon the following authorities. Number 1, Mita India Private Limited versus Mahendra Jain, 2023 SCC Online SC 163. Number 2, MS Dilawari Exporters versus MS Alitalia Cargo and others. MS means measures, okay? M/S. 2010 5 SCC 754. And number 3, Liverpool and London SP and I Association versus MVC Success I and another. Two 2004 9 SCC 512.
Sorry for the interference, Lordship. I have given another judgment, specific judgment regarding Order 7 rule.
No, don't keep on pouring in judgments like that. It will make burdensome.
Sorry.
The next para, the learned counsel thus submits that under the facts and circumstance, the impugned order should be set aside and the matter remanded back for consideration by the learned trial court. Next para. Mr. Lal Fakoma, learned counsel for the respondent number 1, submits that clause 2 of the power of attorney executed between the respondent number 2 and the respondent number 1 does not authorize the appellant, the respondent number 2 to subcontract the work to the appellants. Stop. The respondent number 1, in fact, upon coming to learn about the action of the respondent number 2, immediately instructed the respondent number 2 to stop the execution of the work by the appellants. To stop. He submits that the pleaded case of the appellants in their suit also goes to show that the appellants have indeed accepted the fact that the respondent number 1 asked the work to be stopped upon finding out that it was being executed by the appellants. To stop. The appellant, the respondent number 1 is neither a signatory to the agreement or the power of attorney executed between the parties concerned, and therefore there is no question of seeking a degree against the respondent number 1 for payment of the principal balance amount along with interest as claimed by the appellants in their plaint. Full stop. The learned counsel, in support of his submissions, has drawn the attention of the court to the written statement filed by the defendant number 1, more particularly paragraph number 8, 10, 11, 12 and 13, amongst others. To stop, the learned counsel also submits that he would rely upon the case of Mita India Private Limited, Supra, which was already cited by the counsel for the appellants. Stop. The learned counsel finally submits that rejection of the plaint on the ground of absence of cause of action does not bar the appellants from filing a fresh suit, subject to there being cause of action. First off, he thus submits that there cannot be any legitimate grievance against the impugned order, and the appeal, being without merit, should be dismissed. Next para, Mrs. Dinari Tiazu, learned counsel for the respondent number 2, submits that she supports the argument advanced by the learned counsel for the appellant, and by referring to the impugned order itself, she submits that the learned trial court has also taken note of the fact that taken note of the apex court decision in Mita India Private Limited Supra, that though general power of attorney holder cannot delegate his powers to another person, but the same can be delegated when there is specific clause permitting sub-delegation. Stop referring to clause 2 of the power of attorney dated 12/1/2021. She submits that the executant bracket respondent number 1 has given wide power to the attorney holder power after power, you write wide power and authorization to the attorney holder to do all other things, all other necessary acts and things in regard to the in regard to the work in question on his behalf, and which should be binding and which shall be binding upon the respondent number 1. Stop. She further submits that the respondent number 1 was also aware of the fact that the appellants were undertaking the construction work, as he had occasionally visited the construction site. Stop. Therefore, it cannot be said that the work executed by the respondent by the appellants is unauthorized in view of the enabling provision which can be read in clause 2 of the power of attorney dated 12/1/2021. Stop. Under the circumstance, the learned counsel submits that the impugned order should be interfered with by this court. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. No, before that, I missed out this thing. Counsel for respondent number 1, submission. You just add this. Mr. Lal Fakoma, learned counsel for the respondent number 1, also submits that the essential ingredient to give a valid ratification for acts done by one person on behalf of another is knowledge of the fact that the work is being done, which otherwise is absent in the present case. Stop. In this connection, the Learned Counsel refers to Section 196 and 198 of the Indian Contract Act 1872. Stop. The Learned Counsel also refers to Section 238 of the same Act to contend that misrepresentation made or frauds committed by agents acting in the course of their business for their principals have the same effect on agreements made by such agents as if such misrepresentations or frauds had been made or committed by the principals. But misrepresentations made or frauds committed by agents in matters which do not fall within their authority do not affect their principles. Stop. In the present case also, the respondent number 2 acted without any authority given by the respondent number 1, and therefore the respondent number 1 cannot be made liable for payment of any amount to the appellants. Next, regular para. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. From the above projection, the issue to be decided in the instant appeal is as to whether the learned trial court is justified in rejecting the plaint on account of its finding that the plaint did not disclose a cause of action. Stop. There are several reasons given under Order 7, Rule 11 of the CPC for rejection of the plaint. And in the instant case, the plaint appears to have been rejected under Order 7, Rule 11, bracket small a, CPC. The appellants have contended that there is clear authorization for doing all necessary acts in regard to the work in question, and such acts done would be on behalf of the respondent number 1 and would be binding upon him. Stop. In this connection, clause 2 of the power of attorney dated 12/1/2021 has been referred to. Does this thing find a place in the impugn order? It does not, isn't it? Has it been discussed? Clause 2,
No, Your Lordship.
not discussed.
Not discussed.
Lord God, the submission of the opposite party, even the plaintiff and defendant number 2 is not recorded at all. You are present, you have submission. Nothing is recorded.
Stop. A perusal of the impugned order does not disclose that this aspect of the matter has been taken into consideration before or while passing the impugned order. Stop. Another bone of contention which appears to be attracted is is with regard to the knowledge of the respondent number 1 about the appellants undertaking the work in view of their agreement or power of attorney arrived between the appellants and the respondent number 2. Stop. The respondent number 2 in the written objection filed has also stated that the respondent number 1 had visited the construction site on many occasions, and therefore he was aware about the appellants undertaking the construction. Stop. On the other hand, the respondent number 1 has denied of having authorized the defendant number 2 to delegate the authority of undertaking the construction work further to the appellants. Stop. The respondent number 1 has also denied about his knowledge of the bills raised by the appellants to the respondent number 2. Of such being the controversy raised by the rival parties, this court is of the considered view that it was essentially necessary on the part of the learned trial court to examine the respective claim of the parties before coming to its conclusion about the lack of cause of action against the respondent number 1. Against the respondents. Does it say respondent number 1?
It's only respondent number 1. Because the remaining respondents, defendants are all pro forma.
Pro forma. Is it like that?
Yes, Your Lordship. It's can be ascertained from the cause title.
See, one aspect is that court may find that there are several defendants. Cause of action may not be against one. What about 2, 3, 4?
Yes, Lord.
Now this order covers everyone, isn't it?
Yes, this plaintiff.
Supposing you have no claim against the respondent number 1.
Yes.
What about your claim against the respondent number 2? What will happen?
That's why, Lordship, in Order 7, Rule 11, court cannot reject a plaint as a whole.
I apologize to interrupt on that point, Your Lordship. I have one judgment of the apex court which I slipped my mind. This is a judgment date 2023 SEC online SC 1407. I've given the citation memo.
What does it say?
It basically says that you cannot reject a plaint in part. Either you accept it as a whole or you have to reject it as a whole. At paragraph 12.
So there cannot be any decision with regard to some of the plaintiffs or some of the defendants not being, there being no cause of action.
As per this judgment, Your Lordship, it basically says that the plaint as presented must proceed as a whole or can be rejected as a whole, but not in part.
Okay. Anyway, we'll not enter into that arena as of now. We'll stop. The learned counsels for the rival parties have referred to the provisions of the Indian Contract Act 1872, more particularly sections 196 and 198, amongst others, wherein the determination of acts done without authority and the effect thereof has been provided, and in which the important ingredient would be knowledge of the act being done. Stop further. Section 237 of the same act provides acts done by the agent without authority or incurred obligations to third party on behalf of the principal would bind the principal of such acts or obligations. in the event the agent by his words no, the principal by his words or conduct has induced such third persons to believe that such acts and obligations were within the scope of the agent's authority. To stop, therefore, a determination in this regard, in the considered view of this court, would be necessary before taking a decision to reject the plaint on the ground of lack of cause of action. Stop. Under the circumstance, this court is of the view that the matter should be revisited by the learned trial court by affording due opportunity to all the parties concerned. As observed herein above, stop. Accordingly, the matter stands remanded back, and the parties being represented before the court today are directed to appear before the learned trial court.
May I make one small request, Your Lordship? If Your Lordship can kindly clarify on whether clause 2 of the power of attorney should be deemed to be a subdelegation.
No, that will be a job.
No, my lord, the reason why I'm saying this, the reason why I'm saying this is because the fact that the plaint was rejected as lacking cause of action was because the learned trial court specifically in its order had stated that there was no subdelegation in the power of attorney. There was no specific subdelegation clause in the power of attorney.
That observation and opinion will be rejected, and it'll be open again.
No, I mean, so
No, if we say that there is no sub-delegation, then where's the question of remanding it back?
exactly my point, my lord. Because the reason is that that issue has remained open, and it's going to be confusing for the trial court to.
No, it'll not be confusing. Of course, the parties are there to confuse the trial court, but the trial court should take a call on that.
Revisitation. Very well.
Anyway, I'll fine-tune the order. This is the order of remand. The impugn order dated so and so is hereby set aside. Parties to appear before the learned trial court. When? Next week or after that?
Today is the 3rd.
Today is 3rd.
19, Lordship.
No, 19 I'm not available, my lord. I'll be out of station. The week commencing from 17 I'm not.
17?
No, the week commencing from 17, that week I'm not there.
Okay.
Next week I'm fine, or the week commencing from the 24th, anytime, my lord. Except this particular week of 17. It's just for appearance.
For appearance only, so anybody can appear.
In
Get a
fact,
date.
they were represented in the lower court, trial court also.
When? 14th then? Friday?
I know.
14th of November 2025. Whereafter the learned trial court shall proceed with the matter in accordance with law.
I apologize again. Can it be specific to the senior civil judge 1? Civil judge senior division 1? Because I've faced several.
One,
yes.
Okay, remanded back to the learned trial court, that is the senior civil judge 1, ISO. Okay.
Deeply obliged.
Yes, that is why you all are here to assist the court.
Because it,
We may pass some orders wherein we have to somehow specify things. It's a good thing, you reminded me.
this,
All right.
Item 18.
Lordship, I am appearing on behalf of my senior, Mr. Sida Ramzawa. Lordship, it seems the appellants have been absent for quite some time when called for. So if this appeal may be dismissed without going to its merits.
Appeal may be dismissed.
Yes. As for
None
now-
appears for the appellant when the matter is called. However, Mr. What is your name?
Stephen Lalbuatsaya.
Stephen Lalbuatsaya, learned counsel for the respondent, is present. And he submits that the appellant has been absent on many occasions and therefore the appeal should be dismissed. Stop. However, this court, upon perusing the earlier orders, do not think it appropriate to dismiss the appeal for non-appearance of the appellants today. And considers it fit to post the matter again after 2 weeks. Stop the, okay. It is, however, observed herein that if the appellants are not represented on the next court date, court may consider passing appropriate order. So I think 5 o'clock by ISO standard is a bit late. Anyway, we are in the midst of the thing, so.